Item number 1 and 2.
Yes. If your lordships kindly have a look at page 8 of the paper book. This is all what the writ petitioner had made out as a case. Paragraphs 5 and 6. The petitioner states that he appeared in the examination along with many other candidates and did fairly well, and expecting to be favored with appointment after interview, but to his utter dismay, he found that all the private respondents, along with one Somnath Saha, were selected in the available 5 vacancies for the post of peon and subsequently given appointment to them. The petitioner states that he came to learn from different sources that all the 5 candidates who participated in the selection proceedings along with others and were subsequently selected for the above posts of peon are not eligible to participate in the selection process, as all of them have higher qualification and all the 5 candidates have passed the board examination of secondary level, and they suppressed the above fact, and as soon as the petitioner came to learn of the same, he tried to gather further information by making applications under the RTI Act. Then not, he says not from the RTI Act what is revealable. Please come to paragraph 9 now. The petitioner states that soon after obtaining the aforesaid information, he made representations before the bank authorities, reiterating the above facts that the eligibility criteria of all the 5 selected candidates, being the private respondents herein, had suppressed material facts and had appeared in the selection process as they are not eligible to participate in the selection proceeding for the post of peon, as they are all having higher qualification and according to the recruitment rules or advertisement containing the terms and conditions, they are not eligible to participate for the said post of peon, and further requested them to inquire into the matter and take necessary steps. Then paragraph 10, the bank had transferred us. He gives the details of the persons who had been appointed apropos their educational qualification, and please have a look at the periods at page 16. mandamus commanding the respondents to set aside or cancel the entire selection procedure for appointment in the post of peon in Shuri so and so, wherein the private respondents were selected, commanding the respondents to consider the representations of the petitioner and to take steps for suppression of material facts in violation of the specific terms of such appointment, circularly directing the respondents to produce the records of the case before this honorable court, and on perusal of the same, conscionable justice be administered by setting aside the selection procedure for the post of peon and further direct the respondents to take appropriate steps against the suppression of material facts and interim order in terms of prior so and so. Now, nowhere he says that he is a person qualified and therefore he should be appointed. In terms of the process of selection, not in the, not your lordships have been taken through not that part of the bank stand that 11 persons had been issued interview letters, out of whom 9 had appeared.
There's one petitioner or many?
One petitioner, only single writ petitioner.
Yes.
Number, in this context, vis-a-vis the stand taken by the bank, in fact, not the writ petition was disposed of without affidavits. His lordship held that the qualification is unacceptable. Now that's at page 89. This is the last word in the first paragraph of page 89. To emphasize the point, it was additionally indicated in parentheses that additional qualifications would be unacceptable. But this was the stand taken by the bank.
Yes.
But my most respectful submission before your lordships is unacceptability is different from ineligibility or disqualification. No, this has probably not been produced before your lordships. It had to be in. So one of the SLP, I believe the others are also. There is a review application. There was a review application filed by the bank, which appears at page 106 of the SLP. Now, this was seeking review of the judgment passed by this honorable court in the division bench. Now, ground number 3, surprisingly, is that the division bench has misconstrued the advertisement. So, for ground number 4, 7, 16, and 21. Please have a look at ground number 3 of the review application at page 111 of the SLP.
So in the review, they relied on the advertisement.
I'm not, not par contra, I'm not ground number 6 at 112, not which specifically mentions about a so-called rule of the bank. Which may not, before the Honorable Supreme Court, the bank wanted to justify that we have a rule and therefore the court, the Honorable Supreme Court allowed the bank to go back before the Honorable Division Bench to resurrect our appeal. It is our appeal, not the bank's appeal.
Yes.
I have read not from the provisions of the General Clauses Act. It's the definition of rule. Not and 55. It had to be. Internal page 3 of that notes, I have quoted from the General Clauses Act, section 3, subsection 51. Paragraph 12. A rule shall mean a rule made in exercise of a power conferred by any enactment, and shall include a regulation made as a rule under any enactment.
Yes.
Now, coming back before your Lordship's court, not the bank relies on two documents. One is that not the handed up copy of that 2001 policy, and the other is already annexed to the paper book. Now, please have a look at those two documents. But on consideration thereof, not your Lordships were pleased to frame these two questions in paragraph 5 and 6 of that order.
Which page you are placing? Which page?
But I first placed not the 2001 policy, not which was separately handed up, not in the form of a paper book, but I believe it was separately handed up. It had to which the thing.
Yes. What is it?
Now, this is a policy of 2001, which the Learned Counsel for the bank had handed up. এরকম একটা কাগজ দিয়েছিল, একটা কাগজ হ্যান্ড আপ করেছিল।
It ought to be in the file, in our file. It was given to us.
Yes.
Yes.
Second page টার্ন ওভার করুন, টার্ন ওভার।
Yes, sir. Got it. Yes, you continue. What is the document dated?
It's a document of 19th September 2001.
2001, yes.
Now, this is on the subject of recruitment in banks. I am directed to draw your attention to the announcement made by the Honorable Finance Minister regarding abolition of banking service recruitment boards and providing greater independence to bank managements in forming their own recruitment strategy and implementing it. Banks have already been advised to take steps for closure of the banking service recruitment boards as early as possible. It has now been decided that each bank may frame its own recruitment strategy with the approval of its board to meet its future requirements. However, while framing such strategies, banks may be guided by the following. The recruitment policy should be transparent. The process of selection should be fair, just, objective, and unbiased. Reservations in post of SC/STs, OBCs, ex-servicemen, disabled, etc., with concessions in eligibility norms, as laid down by the Government of India from time to time, should be strictly followed. There should not be any change with regard to minimum or maximum age criteria, educational qualifications as regards workmen, employees, and probationary officers. However, banks may decide the educational qualifications and experience, as well as maximum age in respect of specialist officers to be appointed in officers' cadre. So the specific reservation or not leverage given to the banks was restricted to officers' cadre. The system should be economical and free, and fee change from the candidate, fee charge from the candidates should be reasonable. Candidates belonging to SC/STs may be provided the same concessions in free and cut-off marks to which they are entitled in at present. In the selection committees set up for interviews, due representation should be given to the members belonging to SC/STs and minority communities. The recruitment policy and should not neglect candidates with rural background areas or coming from weaker sections of the society. The recruitment should be need-based, and in any case, it should not be made to fill up the vacancies caused due to voluntary retirement scheme. As advised in this office letter of 26th of April 2001, the recruitment should be made strictly as per manpower plan as approved by the board of directors of the bank. The policy should conform to the instructions issued by Government, Reserve Bank of India from time to time on creation of posts or filling up of vacancies or staff growth. A copy of the recruitment policy framed by the bank may be sent to the government as and when approved by the board. Now, please come to the policy, page 2. Not for us, it will 5.3. I'm sorry, 5.3. For this cadre, it is 5.3. 8 class standard but less than SSC or matriculation. Reservations for SC, ST, OBC, ex-servicemen, physically handicapped, and relaxation or concessions for eligibility would be provided as per government guidelines issued from time to time. Annual assessment of vacancies both in officers and clerical cadre, this does not apply to me. Then selection procedure for all categories of recruitment. Selection of officers, clerical and subordinate cadre will be based on written test, personal interview. Written test shall be conducted by Institute of Banking Personnel Selection or similar all India reputed organization. Then the structure of examination is given at the officers level and not at various levels, including the clerical and sub-staff level. On the next page. Now, this has been explained by the special by the full bench of our court to mean that unless there are good reasons provided in the rule, higher qualification should not ordinarily be taken as a bar. There's that 2010 judgment, not which has been handed up at the time of our argument. But if your lordships will kindly have a look at the judgment, not we can once again place it for your lordship's kind consideration.
You were a respondent in the writ petition.
I was a respondent.
You have never challenged this recruitment policy.
No. Please come to paragraphs 8 onwards of that judgment related to the 8
of which judgment?
That is a full bench judgment of our court. 2010 এটা দেন আচ্ছা দিয়ে দিন আচ্ছা 2 কপি আচ্ছা
This was never under challenge. This recruitment policy was never under challenge.
no not policy is surfacing for the first time before your lordship's court on remand by the Supreme Court.
Whatever it may be, but that policy is reflected in the advertisement
Not,
pursuant to which you applied.
not that qualification, not it says it not be is not acceptable.
Correct.
Now, not whether this is not acceptable is total disqualification.
No, even if it says so, then that amounts to a capping on the higher qualification. So the same issue arises.
But I may have
Whether it would amount to a disqualification or it would not be considered, the issue remains the same, that a higher qualification will not be considered.
will not be considered. Right, they will reckon me or treat me as a class 8 pass standard candidate. Now, not if your lordship will please be.
No, what
come
we
to
are,
that.
why we are asking these questions to you is that when there is never a challenge to this advertisement or to this policy under which the advertisement now they say was issued, can we look into all these things? The legitimacy of the policy, whether it was in accordance with the full bench judgment or not,
No, but
it's not an issue.
But the full bench also was not invited to decide the legitimacy of the policy at the behest of persons who lost their employment. But the question came up before the honorable court in the course of not the proceedings where not their services were terminated on such ground.
Let's see.
Yes. Now, please come to not paragraph 1. The appeal has been placed before us on reference made by a division bench of this court by order of 29 July 2008 for consideration of the following question. When a particular qualification is laid down in an advertisement, specially creating a distinct class of candidates that would be eligible, can the candidates possessing qualifications higher than those advertised be considered and appointed on the post? Now, the facts giving rise to this appeal broadly stated are as under. The Children Development Project Officer of so and so issued an advertisement dated 6 December 96 inviting applications for the post of Anganwadi worker, stating that in the age group of 18 to 45 years, quote unquote, who have passed in matriculation or equivalent examination in with Bengali are eligible to apply. Graduate women are not meant for the said post. But there was a clear embargo in the advertisement. The advertisement also indicated as under, the candidates will belong to the concerned village so and so. The appellants herein, 3 in number as well as another person, and the writ petitioners amongst others applied in response to the advertisement. After written test and interview, the respondent authorities prepared a select list and appointed the appellants and others on the post of Anganwadi worker in the year 98. The writ petitioners, 2 in number, who were unsuccessful candidates at the said selection, filed the writ petition in the year 1999 challenging the selection and appointment of respondent number 6 to 9 in the writ petition on the ground that they were graduates and therefore barred from applying for the post of Anganwadi worker. The private respondents did not controvert the fact that they were graduates at the time of applying for the post, but contended that graduates were not ineligible to apply for the post. It was also contended by the private respondents that by memorandum of 9th November 1983 issued by the state government, graduate Anganwadi workers were eligible to be appointed as supervisors, and therefore, by necessary implication, graduates were not debarred from applying for the post of Anganwadi worker, which was the feeder cadre for supervisors. After hearing the learned counsel for the parties, the learned single judge held that when the advertisement specifically mentioned particular qualification of matriculation and also provided that graduate candidates were not to apply, the private respondents being graduates, they were not entitled to be appointed on the posts of Anganwadi worker. The learned single judge further took the view that when the advertisement indicated that since the graduate women were not to apply, other graduate women did not apply, and that if the private respondents were eligible, the other graduate women would also have been eligible, but they were denied their right of being considered for appointment, and therefore there was violation of Articles 14 and 16 of the Constitution. So this was the specific case made out. During pendency of the appeal, the division bench had granted stay, but here also there is a stay not in filling up the resultant vacancies arising out of our termination.
Yes.
So that particular sentence of the advertisement was explained by this court to mean that it did not completely debar higher qualified persons. Paragraph 7, 8, and 10.
In that case, as it appears from reading this judgment, a provision in the scheme making it mandatory to state in the advertisement that it would lead to a removal or disqualification, or it would be made a ground for cancelling such or annulling such recruitment. And there was no such a specific provision stated in the advertisement. So that was taken by the court into consideration. Then the fact that they had continued for 12 years.
And that was another aspect of the matter. But not if your lordships kindly have a look at paragraph 8.
Yes.
Not 7, 8, and 10. When I read these three paragraphs, please have a look at paragraph 7.
Yes.
Having heard the learned counsel for the parties, we first take up the preliminary consideration urged on behalf of the writ petitioners that the appellants and other private respondents had suppressed the material fact that they were graduates.
Yes.
It is true that the scheme of
this is what we are saying. Yes, it
the
is true.
scheme of 1985, under which the advertisement was issued, provided that the advertisement should state that should a candidate suppress any relevant information or furnish false information, particularly regarding her age, residence, and educational status, her appointment may be terminated at any time. However,
This was not. This was absent in the
in
advertisement.
the advertisement. However, this was not mentioned in the advertisement, and the advertisement merely stated that those who are matriculates are eligible to apply, and that the graduate women are not meant for this post. This sentence in the advertisement could hardly be considered as a prohibition against graduate women applying. But similar is the case here.
So you are equating are not meant and unacceptable.
Nor can it be treated as a ground to disqualify or penalize a graduate woman for not having mentioned her graduate qualification in the application. 10, paragraph 8. Coming to the merits of the controversy, it is true that in so and so, reported in so and so, the apex court took a prima facie view that the criterion which has the effect of denying a candidate his right to be considered for the post on the principle that he is having higher qualification than the prescribed cannot be rational. But in the facts of that case, the apex court upheld the application of such a criterion the apex court upheld the selection process in that case on the ground that the process was already completed, but it is necessary to note that the apex court applied the test of equality as enshrined in Articles 14 and 16 of the Constitution. That reasoning would not be available in the facts of the instant case because the very scheme of Anganwadi workers and the nature of their engagement has been recently considered by the apex court in so and so. In paragraph 20 of the judgment, the apex court had held that Anganwadi workers do not carry on any function of the state and they do not hold a post under a statute. The state is not required to comply with the constitutional scheme as adumbrated in Articles 14 and 16 of the Constitution. In view of such emphatic statement of law, it is clear that the contention urged on behalf of the appellants based on Articles 14 and 16 cannot be accepted. It is, however, not necessary to pursue this discussion any further because we have already held that the advertisement did not specifically debar or disqualify graduate women from applying for the post of Anganwadi workers, and therefore the engagement of the appellants and the other private respondents in the writ petition as Anganwadi workers could not be said to be illegal on the touchstone of the advertisement. It is true that if the provisions of the scheme were to be applied, the appellants and the fourth private respondent would be in difficulty. However, having regard to the fact that the appellants and others were appointed way back in 1998 and they have continued in employment for the last 12 years, and the advertisement specifically did not disqualify or debar graduate women, we are not inclined to disturb their appointment. So, not dual grounds. One was equity, the other was the advertisement did not debar.
The first ground by itself, could it be sufficient? It is a 3-day bench, but yes.
7 months for me, of course.
No, even if there are so many judgments of the apex court, not much after the, what is that, Kurukshetra University was the leading case. That has been subsequently, the view has shifted quite a bit.
If it is illegality, even long continuance will not
equity will not accrue in the favor of a person. Equity begets equity. That is the whole concept.
Long continuance does not ripen into a right.
So that was Kurukshetra University that was the law.
The students who had disclosed their all credentials, and the university was held to be stopped.
Yes, there was a full disclosure there. And in fact, if we remember correctly, there was a lot of deliberation also on this. It was within their knowledge. Still no action was taken.
Now, today we are pondering over the language employed by the bank vis-a-vis the advertisement and the policy of 2001, 2020 policy. What is the meaning of rule and how the Honorable Single Judge has also understood this. Not as a complete disqualification, but as a mere unacceptability. And we are also considering the fate of the writ petition vis-a-vis an unsuccessful candidate, which the Honorable Division Bench has specifically mentioned this to be. Apart from the language used in the advertisement, there is no further rule forthcoming before your Lordship's court to show that there is a complete debarment.
Still no rule has been shown. That is what you are contend. There is no change.
No change of situation, which may warrant a revisit to the Honorable Division Bench order.
And in this connection, you rely on General Clause Act.
Now, rule-making power in the bank, these are all laid down under the Banking Regulation Act, how rules are to be framed. That's in section 52. I have indicated in my note, I need not detain your Lordships. The central government has to be consulted for that purpose. And if there is a reasonable doubt raised in the mind of the court, either in law or on fact, Not this has always to be not held in favor of the persons not who are weaker. Who are weaker. A reasonable doubt both on law and on fact has to be held in favor of the weaker section. But that was Justice Krishna Iyer's view in 1978. But one particular sentence from paragraph 5 of 1978 to SCC page 42. Now, of course, this arose out of a bonus dispute, but please have a look at the sentence at paragraph 5 of that report.
Yes.
This is one aspect of the matter. The other aspect is not what are we detaining ourselves for? At whose behest? Not apart from those bare statements at paragraphs 5, 6, and 9, nothing has been pleaded by the writ petitioner. That had these appointments been set aside, he would have been automatically appointed to the post. And even if we so, not he could have only knocked out one of the respondents and not all.
So no positive relief was made out.
He only seeks for quashment of the process and no relief. So not he this is a writ of mandamus. He ought to have made out a case of an enforceable right being sought to be vindicated. He should have shown that I am the sixth candidate. If these 4 persons are knocked out, I get an appointment. The 4th person is knocked out, I get an automatic appointment. Now, please come to page 6 of that compilation I have handed up to your lordship. It's 1998, volume 6, SCC 741.
Existence of a right.
Why not? Please come to straightway come to running page number 11. Paragraph 6.
Yes.
But please see the third sentence of that paragraph. The sentence begins with the words, thus, when the respondents approached the court. They could not even claim that they had a chance of promotion at that time. The writ petition ought not to have been entertained at their instance. In view of the passage of time, we do not propose to rest our conclusion on that aspect of the matter. That was a different consideration. But writ petitions are tried on affidavits, where the pleadings are not the evidence and the annexures are exhibits. Now, please come to another judgment of our court. I know not citing a single bench judgment before a division bench is not a virtue, but not its single bench judgment of our court begins at page 15, 1998, volume 2, CLJ 365, paragraph 14, at page 21. There are two or three factors, issues which were being considered by the court. Now, please come to the last consideration. The sentence begins with the words lastly, probably the fifth or sixth line from the end of that paragraph, 14 at page 21. Just after the marks being recorded, it says, lastly, if the respondent. Lastly, if the respondent number 7's appointment is set aside, in that case, the second empaneled candidate would get the chance, but the writ petitioner who had secured the third position in the panel would not be selected. In the present case, the vitally affected person, if any, is the second empaneled candidate, but under no circumstances the writ petitioner can claim for a selection having secured the third position in the panel. Thus, by the impugned selection, no legal right of the writ petitioner has been impaired. That's why he has consciously not prayed for setting aside of the appointment and his appointment to the post of peon. Because he has not made out any case that he would be benefited by reason of quashment of the process. Remember, the last one is AI 1962 Supreme Court 1044 paragraph 5, running page 24 of that compilation.
Page?
Running page 24. AI 1962 Supreme Court 1044. The first question that falls to be considered is whether the appellant has locus standi to file the petition under Article 226 of the Constitution. The argument of learned counsel for the respondents is that the appellant was only managing the industry and it had no proprietary right therein, and therefore it could not maintain the application. Article 226 confers a very wide power on the High Court to issue directions and writs of the nature mentioned therein for the enforcement of any of the rights conferred by Part 3 or for any other purpose. It is therefore clear that persons other than those claiming fundamental rights can also approach the court seeking a relief thereunder. The article in terms does not describe the classes of persons entitled to apply thereunder, but it is implicit in the exercise of the extraordinary jurisdiction that the relief asked for must be one to enforce a legal right. In Madan Gopal Rumta, this court has ruled that the existence of the right is the foundation of the exercise of jurisdiction of the court under Article 226 of the Constitution. In Chiranjit Lal Chaudhary, it has been held by this court that the legal right that can be enforced under Article 32 must ordinarily be the right of the petitioner himself who complains of infraction of such right and approaches the court for relief. Not this is sentence, not allegation. We do not see any reason why a different principle should apply in case of a petitioner under Article 226 of the Constitution. The right that can be enforced under Article 226 also shall ordinarily be the personal or individual right of the petitioner himself, though in the case of some of the writs like habeas corpus or quo warranto, this rule may have to be relaxed or modified. When this principle is applied in view of the 1992 CLJ judgment, where the court holds that unless he can be benefited by reason of an order being passed, no right can be vindicated as such through enforceability in 226 jurisdiction. And on the face of the foundational pleadings in the writ petition, vis-a-vis the stand taken, I most respectfully submit that the bank has miserably failed to dissuade this honorable court to not deviate from the findings of the honorable division bench by reason of non-production of a quote-unquote rule as is understood within the meaning of the General Process Act. Now, these are my submissions.
Yes.
Is it my lord pleasure that lordship hears the bank?
Yes, you may.
That'll be the last one.
My lord, all this, my lord, submissions regarding the advertisement and the understanding of that expression which is used in Bengali vernacular, grohon jogyo hoibe na. My lord, kindly sees the memorandum of appeal. What was their understanding, the appellant's understanding of that, my lord, language? My lord, kindly comes to the paper book, page 129, one ground 8.
No, that is, see, the Honorable Single Judge has translated that provision.
As not acceptable.
Unacceptable.
Unacceptable.
You never challenge the Single Judge judgment.
Even I am saying, my lord, that it's unacceptable.
So therefore, we need not delve any further.
Yes.
That interpretation or the translation done by His Lordship is not questioned by you.
Very. I am also not
Now, when it says unacceptable, what is the consequence? That is
and
only.
what is the meaning of that
It
expression?
is the meaning of that
Now,
expression.
that meaning, my lord, that meaning would
Whether
be, my
it
lord,
entails
called
a
out.
disqualification or whether it does not entail a
Well,
disqualification.
it's according to me a disqualification. According to me, it has been understood to be a disqualification even by the appellants. And for that purpose, I want to draw my lord's attention to ground 8. Kindly comes to my lord, page 120.
Before the apex court.
No, the appeal which is filed, the appeal which is being heard. My lord, it's part of the paper book. Kindly comes to the memorandum of appeal, starts at page 123. My lords may kindly come to page 129. For that, the honorable judge ought to have held that the advertisement which the appellant came to know for the first time from the advertisement published in Bartaman Potrika, which is Annexure P1 to the writ petition, prescribing upper limit of education up to class 8 pass, but unsuccessful in matriculation or equivalent examination for the post of peon, and also prescribing upper limit of education is without reasonable basis. And as such, the same is arbitrary and violative of Article 14 of the Constitution of India. This is the ground on which, my lord, they attack the order of the learned single judge.
See, this we have been considering this expression repeatedly. That translation which has been done from Bangla to English, that is
Not
off the mark. It cannot be unsuccessful in matriculation. It should be not passed. It is not, does not contemplate that one has appeared and then he has become unsuccessful therefore. The advertisement probably wanted to say not matriculation pass. So
but the language in the Bengali, my lord, it says অতিরিক্ত শিক্ষাগত যোগ্যতা গ্রহণযোগ্য হবে না. My lord, অতিরিক্ত here would mean anything beyond matriculation.
Should not be accepted.
It should not be
unacceptable,
yes,
as his lordship interpreted.
And অতিরিক্ত would mean beyond matriculation.
Unsuccessful in matriculation, that appears to be untenable by any standard.
That is the ground, my lord. They have, my lord, pleaded in the appeal.
Probably the advertisement wants to say not a matriculate.
Not a matriculate. Yes, not a matriculate.
Unsuccessful in matriculation. So if you fail, then
not a matriculate. Let us keep it there, my lord. Not a matriculate. Class 8 pass, but not a matriculate.
Only if you fail in matriculation, then you can apply that.
No, that is not possibly the meaning of the advertisement.
That's possibly the advertisement, actually so, because it says who has not passed matriculation.
Please read the Bangla version of that. What does it say?
কিন্তু matriculation পরীক্ষায় অনুত্তীর্ণ, one who has
not passed, not unsuccessful, not matriculation passed. That is a general way of stating it in the advertisement.
So, my lord, the two pillars are, my lord, class 8 pass and, my lord, not beyond matriculation.
So not matriculate.
Not matriculate. And that is, my lord, what
so
they
up
also
to 9th they don't disqualify.
They don't disqualify.
They want 8th But even if you are ninth, you say we don't disqualify, we disqualify. The moment you pass a matriculation, you are disqualified. That is your case.
That is my case. And my lord, they also understood it. The appellants also understood it in that manner. Otherwise, this ground would not have been there.
So we
This-
will take it as not passed if it is already not passed.
Then, my lord, one more ground, page 130, ground 10. For that, the Honorable Court below acted without jurisdiction in not considering that there is no rule or law prohibiting to a person having higher qualification from getting opportunity for appointment only by giving preference to less educated persons. And in the absence of such rule, the appellant cannot be debarred from participating in the selection process. So this also would be interpretation of that, my lord, advertisement. Whether it is, my lord, after matriculation, can you, my lord, a person who possesses higher qualification participate in the process or not?
That is their challenge to the judgment of the single judge. Before the apex court, you introduced the concept of a rule.
Yes, I did. And that is the reason why it was remanded after setting aside the previous orders. And now Lordship is hearing the appeal afresh. Now, my lord, when we use
No, but when we are hearing the appeal afresh, we must consider the reason for which it was
Lordship
sent
would,
back.
definitely Lordship would, and I'll address on the rule aspect also, the rule argument which has been made by Mr. Mojumdar. But before that, my lord, let us, my lord, only consider this part, whether at any point in time in this proceeding, there is any challenge by the appellants to the effect that this is not the rule, or that they are challenging the, my lord, advertisement or the process which was followed by bank, because they participated under the same process. It is not that they are challenging that, my lord, advertisement per se. They say I fit in the advertisement terms, and my appointment which was granted could not have been set aside by the learned single judge. This is their case. So there is no challenge to, my lord, the terms of the advertisement, or to the, my lord, rule making power of UCO Bank in, my lord, publishing the advertisement. There is no ground to that effect. Now Lordship may ask me a question that situation did not come because it is only after the Supreme Court's order that it has been remanded, and Mr. Mojumdar for the first time is arguing that. But the appeal has not been amended to incorporate this as a ground. My lord, so far as the document is concerned of 2001, if Lordship kindly takes it once again, my lord, this is, my lord, a guideline issued by the Ministry of Finance.
That's September 2000.
That's September 2001.
99.
My lord, 19 September 2001.
99.
2001, my lord.
99.
19/9/2001, right.
Yes.
My lord, I read the, my lord, first, my lord, paragraph once again. I am directed to draw your attention to the announcement made by the Honorable Finance Minister regarding abolition of banking service recruitment boards and providing greater independence to bank managements in forming their own recruitment strategy and implementing it. So, my lord, the Ministry of Finance is, my lord, by this guideline giving the power to the chief executive officers of all public sector banks to frame their own recruitment strategy and to implement that. Mr. Mojumdar drew particular attention to clause 4. My lord, kindly comes to clause 4, and my lord, and I thought an impression was being given that it is only in respect of officers cadre. My lord, I beg to differ, my lord, if Lordship kindly sees, my lord, from clause 1, it is a general, my lord, guideline. Recruitment policy should be transparent. Process of selection should be fair, just, objective, unbiased in all aspects, and provide equal opportunity to all eligible candidates. Clause 3 talks about reservation. Then clause 4, there should not be any change with regard to minimum, maximum age criteria, educational qualifications as regards workmen, employees, and probationary officers. However, Banks may decide the educational qualification and experience as well as maximum age in respect of specialist officers to be appointed in officers cadre. This is just, my lord, an exception carved out for officers cadre, where it is the guideline says that the bank can decide the educational qualification themselves. Then, my lord, kindly turns the page.
Perhaps this is because BSRB was earlier conducting the recruitment process for recruitment of probationary officers. The BSRB was earlier conducting these examinations.
Yes.
So after abolition of BSRB, this has been issued.
Yes.
Therefore, it is perhaps.
Now, my lord, last, my lord, clause 8 and clause 10. The recruitment policy should not neglect candidates with rural background areas or coming from weaker sections of the society. And 10, policy should conform to the instructions issued by government or Reserve Bank of India from time to time on creation of posts or filling up of vacancy staff. Copy of the recruitment policy framed by the bank may be sent to government as and when approved by the bank, by the board. Now, my lord, the recruitment policy of UCO Bank is the next document which I had placed on the last day. If your lordship kindly comes to internal page 2 of that document. The, my lord, Genesis part. Before
Yes.
Before 1979, the bank used to conduct recruitment of its own personnel, namely in subordinate cadre, clerical cadre, and officers cadre, including specialist officers depending on need-based requirement. However, after creation of Banking Service Recruitment Board, the recruitment process was not directly handled by the bank, but was conducted by banking service recruitment boards. Recruitment of subordinate staff, even after creation of Banking Service Recruitment Board, was conducted by the bank itself through employment exchanges. There has now been a shift in the government policy. And after abolition of banking service recruitment boards, public sector banks are required to frame their own recruitment policy based on the guidelines conveyed with a Government of India Ministry of Finance Banking Division letter dated so and so. 19 September 2001. The recruitment policy framed is based on the guidelines mentioned in the aforesaid government letter. So this is, my lord, the recruitment policy. Now, kindly comes to clause 5.3, my lord, which is the only relevant clause, my lord, of this recruitment policy for the present appeal. This should be, my lord, internal page 4 of that document, my lord, of the policy document. The page numbers are at the top of the pages.
Subordinate staff.
My lord, subordinate staff. 8 class standard, but less than SSC matriculation, as rightly lordships were observing, that it is, my lord, you have to be class 8 pass, but less than matriculation. And, my lord, the advertisement also is in line with the recruitment policy, that any extra qualification, it would not be acceptable. Why it would be not, or for what purpose would it not be acceptable? For the purpose of considering whether you would be given this post of peon or not. Now, from time to time, my lord, this policy has received the consideration of the board of directors of UCO Bank. My lord, to that effect, if your lordship just takes a note of, my lord, the page starting after the last page of the policy document. My lord, the policy ends at internal page 10. This is a resolution, my lord, where, my lord, the board was considering whether to review or amend the recruitment policy of UCO Bank. It should be just after page 10.
Yes, we have seen it.
Yes. So this is, my lord, as late as on 14th of May 2019. And the same policy is continuing because the board has resolved that it has approved the same policy. So there is no shift. Now, my lord, Mr. Mojumdar was relying upon Section 52 of the Banking Regulation Act. I don't dispute, my lord, section 52, which gives the rule making power. In addition, I just want to draw my lord's attention to one more provision of the, my lord, Banking Companies Acquisition and Transfer of Undertakings Act 1970, which also gives power, my lord, similar power to the, my lord, to make the rules. Kindly takes, my lord, section 19 of this act. My lord, I'll give, my lord, copies. See? My lord, there are two distinctions. One is in respect of public sector banks, which is UCO Bank. My lord, there are, my lord, structural and, my lord, administrative rules, which are, my lord, aligned with the, my lord, guidelines issued by the ministry. My lord, so far as other companies, my lord, are concerned, which are banking companies, for them, my lord, again, kindly sees, my lord, just for reference. Section 19, Board of Directors of a corresponding new bank may, after consideration with Reserve Bank and with the previous sanction of central government, make regulations not inconsistent with the provisions of this act or any scheme made thereunder to provide for all matters for which provision is expedient for the purpose of giving effect to the provisions of this act. Then 2, in particular and without prejudice to the generality of the foregoing power, the regulation may provide for all or any of the following matters, namely, kindly takes, my lord, D, the conditions or limitations subject to which corresponding new bank may appoint advisors, officers, or other employees and fix their remuneration and other terms and conditions in service. So power is given to the board of directors of bank, be it, my lord, a banking company under the 70 Act, or be it a public sector bank, my lord, who is governed under the, my lord, 52 Act. And, my lord, here, my lord, there are guidelines of the, my lord, Ministry of Finance, based on which, my lord, the board of directors of UCO Bank has aligned and framed a recruitment policy. And the advertisement is published on the basis of such recruitment policy of UCO Bank. Now, 2 pages, my lord, I want to show from the paper book. My lord, the format of the, my lord, application and the application which was filed by this person. My lord, kindly comes to, my lord, first page 78. It starts at page 77. My lord, kindly comes to page 78, which is the format. And this is again, my lord, part of the stay petition which has been filed by Mr. Mojumdar's client. Well, at page 77, the document starts the format. The translated copy according to them. At page 78, my lord kindly takes note of clause B. Academic qualification, part-time sweeper, up to 8th class additional educational qualification will not be accepted. My lord, for this matter, the first matter, it is only peon. So I am concentrating only on the first part. I'm sorry, yeah, for the second part, for the post of peon, past 8th class but not past matriculation. Lordship has had also indicated that the general meaning of that advertisement is not past matriculation or equivalent examination. In this case also, additional qualification will not be accepted. Now, how did he file?
The draft application
I was 94. Well, now kindly comes to page 93, capital A, the application which was filed by the appellant. In fact, 93 Lordship first comes, it is in Bengali and the translated copy is in 93A. 93 Lordship takes first. My lord, clause 7 is Shikhagota Yogyota, where in Bengali it is written Ashtom Sreni on 5th of July 2015. I'm sorry, it, my lord, Bengali 7 looks like English numerical 9.
Clause number
7, my lord. In Bengali 7.
educational qualification.
Place
You place it.
Yes. My lord, kindly sees, my lord, clause 7 in Bengali, it says Shikkhagoto Joggota. The declaration is Ashtom Sreni. So the candidate says on July 2015 that I am only class 8 pass. And for the benefit of Justice Prasad, my lord, kindly comes to my lord 93A, my lord, the translated my lord English version. দেখাচ্ছি। My lord, 93A is the, my lord, what they have given in the translated version. Clause 7, educational qualification,
Very well. We have got
class 8 passed. Now, my lord, one more document, my lord, a declaration at page 93B. This is because, my lord, in Rina Dotto, my lord, a similar situation was not there, that if I give a false declaration or a false particular, what would be the effect? My lord, 93B. It is hereby, my lord, the paragraph just after clause 11. It is hereby declared that there is no case in any court against me have not been proved guilty as per law by court. I further declare that all information mentioned in this application are true and correct. If any information is proved to be false or incorrect, and if in any case the condition of the eligibility fixed by the bank is not fulfilled, then my candidature appointment letter will be cancelled. আর কিছু দেখাও? Now, with regard to the praise in the writ petition, my lord, kindly comes to, my lord, page 161. My lord, as the bank, I am really not concerned who is, my lord, to get the post of peon. I am not favoring any person or I am not disfavoring any person. I am only here to, my lord, address on the issue of, my lord, point of law. My lord, the writ petitioner, when the writ petition was framed, only challenged the selection procedure being in violation of the advertisement terms and the rules of the. My lord, if, my lord, the writ petitioner succeeds, even after, my lord, the, my lord, appellate proceedings are over, my lord, the consequence would be that the division bench would be declaring that the procedure for appointment was contrary to the terms of the advertisement, and, my lord, the person who has secured the post of peon would not be entitled to continue the post with the post. This is the, my lord, consequence. And so far as, my lord, the submission that the bank is now challenging bank's own action, my lord, it has been unearthed, my lord, this we discovered or we unearthed this fact only when the writ petition was taken up for the first time. And, my lord, the bank was requested to write letters to the, my lord, concerned persons and get their, my lord, affidavits from, my lord, notarial affidavits stating whether they have that particular educational qualification or not. And once it came, it became clear that yes, their qualification was more than what was prescribed under the advertisement. And naturally, thereafter, the learned single judge felt that it was not correct and set aside their appointments.
yes.
My lord, with regard to the judgments which Mr. Mojumdar cited, 1998 6 SCC 741 and 1992, my lord, the Calcutta Law Journal judgment, I don't dispute the proposition per se, but these judgments do not apply to the facts of this case. Because, my lord, the grounds in the memorandum of appeal are also not in this line. Their ground of attack is that the law does not prohibit a person with a higher qualification to secure a post where the advertisement says that this would be the 2 pillars for consideration. This is their ground of attack, which I showed from ground 8 and ground 10. My lord, with regard to the judgment reported in 1978 2 SCC 42, paragraph 5, Mr. Mojumdar cited, if there is a reasonable doubt in law and in fact it should be given, the benefit should be given to the weaker section. Again, as a proposition, my lord, no dispute. It's a well settled proposition, but cannot be applied to these facts when, my lord, this, my lord, fraud has been discovered. You secured the post, by making a declaration which according to your own knowledge is not correct. And so far as my lord Rina Datta judgment is concerned,
Yes.
the Rina Datta judgment, my lord, there was no, my lord, in the advertisement condition or the, my lord, rule, there was no similar, my lord, condition that if it is ultimately found to be incorrect or fraudulent, then you have to, you will be terminated or your appointment would be annulled or cancelled, which is there, my lord, present in my case. And the declaration is also there from the appellant himself. And I cited, my lord, a recent judgment of 2026 Supreme Court, my lord, which according to me, my lord, discusses the law, my lord, in paragraphs 10 to 12. My lord, this was 2026 SCC Online SC 1048. General Manager HR and another versus K. Puvarasan. My lord, I cited this on the last day. Lordship had taken note of that, my lord. Paragraphs 10 to 12 are the relevant paragraphs of this judgment. If Lordship wants, I can just.
Not required.
My lord, just gives me 1 minute. My lord, those are my respectful submissions.
Yes.
My lord, the first thing I'll be submitting before lordship, my lord, I'll take my lord, one thing that the earlier division bench judgment is not there. Rightly or wrongly, the Honorable Supreme Court has set aside the entire order. And my lord, with duly case, your lordship,
Rightly, not wrongly. There's no question of wrongly.
rightly.
For us, it is rightly done.
Yes, lordship.
For all of us in this court.
Yes, lordship. My lord, this single bench judgment that was passed in my favor, allowing the writ applications, the last paragraph of the said judgment I will place before lordship. My lord, that is at page 89. I'll place it before lordship.
Yes.
This is at page 91, the last line. The bank will complete the recruitment process by engaging the other persons participated in the recruitment process as subject to the same as to education qualifications done to cost. So it's not that, your lordship. My lord, the entire selection procedure has been set aside. There's a direction upon the bank to proceed further with all the eligible candidates. To fill up the
It was
post.
granted to you also.
Yes, I was there.
So what you are trying to submit is that some relief was granted to you also.
Yes. And your lordship, I would refer to your lordship second documents, only two of the documents. One is your lordship, the employment exchange card. And your lordship, take my lord, the employment exchange card is at page 92. The very next page, your lordship. This is all the series of cards are there, 4 or 5 cards of all the respondents. One, this is of Shahid Datta. My lord, we take the date of registration. Date of registration. Date of registration. And my lord, the date of the advertisement that been issued by the bank, your lordship, can you have a look into it? That is, your lordship, 18th of March 2015. It will be evident.
From where you are showing that registration is of 2015?
Not 92, your lordship. My lord, your lordship might be taking the other paper book. This is your lordship of 484 of 2016. The first matter. 484.
No, we have been throughout considering 485. So why don't you refer to 485?
My lord, this is I giving 484. I'm going through it.
No, the same thing must be there in that case also.
The page are a bit.
You take the trouble. We will not take the trouble.
My lord, this is not filed. I didn't file it, Your Lordship.
Who is appearing in 485? You are appearing in 485 also.
Yes, I am appearing,
Then
but I am
refer
appearing.
to 485.
Yes, Your Lordship. My lord, page 91, Your Lordship.
Yes. The identity card.
Yes.
October 2015.
My lord, this is with me, Your Lordship. This is at page 92.
That is a certificate of OBC.
No. My lord,
So that is your case. We have seen that what you are saying is that we were registered long back. At that time, whatever qualification we had, we have mentioned.
no, it's not that. My lord, kindly 2072, Your Lordship. FMA 2072.
Yes.
Take that. The applicant had registered the name on 19th of March 2015 only.
Yes.
And the date of publications of the advertisement, my lord, that is on 18th of March 2015. Just 3 days prior thereto, this registration was done.
In all the cases.
Yes. Now, the next page, Your Lordship, this is of Uber Shah. His registration is 23rd of March 2015. Also 2015. And my lord, kindly look into the qualifications that been stated up there. The first one, 6 qualification, 8 pass. In the case of Sharad Datta, Shah also 8 pass. So he has stated out here that he passed 8, class 8. When by this time, Your Lordship, they had passed, most of them, few of them had passed their graduation, and the other few had passed their passed class 12 examination, as will be evident, my lord, from their declaration, and further from the information that I had received, my lord, after from the from applications being made to me by RTI. One of the application I showed, that is at
We just saw one.
35 to 37.
We just saw one. The bank has placed one where they have mentioned 8 pass.
35.
Yes, we have just seen it.
35, Your Lordship. This is at page 33.
Yes.
It says that Ramesh Manda is to certify that Ramesh Manda was a bona fide student of class 12 of this institution. And he did it in 2011.
That's not in dispute. That is not in dispute that they have higher quality. They have never said that we don't have higher.
Willful submission.
All right.
So that is it, Your Lordship. That's what I'm trying to establish. It's willful.
We have given a declaration, we have signed declaration which was placed by the bank. Irrespective of the facts preceding that, a willful representation is obvious from their form submitted where they have said that it is true to the best of my knowledge, and if anything is found contrary, consequences will follow. So this is not in dispute. Unnecessarily, these issues need not be gone into. They never said that they were not overqualified. They said that yes, we were overqualified. They say unacceptable does not mean I will be disqualified. That is the only.
Wait.
And plus, this unacceptable, whatever.
Wherefrom it would be evident that they had stated that they were not overqualified. It was only after the entire things came into surface. It was never the fact it is never the thing is this, that they had disclosed that they have high qualification.
You were listening to it. We have just seen the
That is
form.
in the subsequent form, your lordship, nowhere they had stated that they passed, means they have high qualification.
Exactly. So we have just seen it.
Yes, yes.
You are restating the same thing. That is precisely what we are saying. That may not be required.
Means what I tried to get out before your lordship, that these registrations being made very recently.
Sir, the
Very
bank
recently.
already used the word fraud.
Yes. Yes, your lordship.
Yes.
So on that score, your lordship, we have resubmit before lordship that the trial court judgment is correct one, and necessary order be passed on that score.
Very well.
Yes, lordship. And another matter would be preferred to a judgment, your lordship.
Give.
My lord, this is your lordship 2012 AIR 2012 SC 1818 My lord, I'll be referring to your lordship. My lord, two, 3 paragraphs, your lordship. 29. We have considered the entire matter in details. In our opinion, it is too well settled to need any further reiterations that all appointments to public office have to be made in conformity with Article 14 of the Constitution of India. In other words, there must be no arbitrariness resulting from any undue favor being shown to any candidate. Therefore, the selection process has to be conducted strictly in accordance with the stipulated selection procedure. Consequently, when a particular schedule is mentioned in an advertisement, the same has to be scrupulously maintained. There cannot be any relaxations in the term and conditions of the advertisement unless such a power is specifically reserved. Such a power could be reserved in the relevant statutory rules. Even if power of relaxation is provided in the rules, it must still be mentioned in the advertisement. In the absence of such power in the rules, it could still be provided in the advertisement. However, the power of relaxations, if exercised, has to be given due publicity. This would be necessary to ensure that those candidates who become eligible due to relaxations are affordable and equal opportunity to apply and complete. Relaxations of any conditions in advertisement without due publications would be contrary to the mandate of quality contained in Article 14 and 16 of the Constitutions of India. Well, what in this case, Your Lordship, the advertisement specifically says something, especially with regard to the qualification. Well, which was not complied, my lord, by suppressing that, Your Lordship, the appellant had participated in the proceeding.
Yes.
So that is
Very well.
Page 89 of the paper, that's the bank said that they committed a mistake. Not a case of misconduct or commission of fraud. Please have a look at the stand of the bank before the honorable single judge. On my appeal, there cannot be a shift of stand at the behest of the bank. Paragraph 2 at page 89. Second paragraph of page 89. Petitioner is justified in the petitioner's assertion that the bank has committed a mistake in giving the appointments to persons who were disqualified from participating. Remember that employment exchange, that obviously was the renewal date, not the original date. But when the bank had asked me to disclose this as an employment exchange sponsored candidate, I said that I have recorded and I have responded as an employment exchange sponsored candidate. That requisition is still not disclosed by the bank. But the 2026 judgment proceeded on the basis that the bank had written to the employment exchange, putting a cap on the educational qualification. This requisition to the employment exchange is still not disclosed by the bank.
Well, yes.
Now, please also have a look at page 91 and 92. 91 and 92.
Yes.
When serial number figure is referred to, the official gazette make regulations. Remember what the regulations may cover are adopted in A, B, C, D, E, F, G, H like that. So the primary condition is notification in the official gazette before these regulations can be said to have been born.
Yes.
And if this is not done in accordance with 19(1), consequently of 2(d), then this is not a rule which requires a reopening of the process. These are my
Item number 3.
My lord, in item number 3, I am making the submission on instructions. Perhaps Reserve Bank of India is a party to this proceeding, but we have not been served. That's my instruction. With regard to item numbers 3, 4, and 5, all the 3 appeals which are before your lordship today.
Yes, your response number 3.
Yes, now, my lord, there are connected appeals which are numbered as mat number 1249, 1250, and 1252 of 2026.
I'm on BC, Lordship.
Wherein we have been served. And from there, Annexure C to one of such leave to appeals, we have come across this detail where we find that the assignment order was passed on 29th of July 2026, pursuant to which these 3 mat numbers have been assigned before your lordships. So may I just pray for the appeal papers be served upon Reserve Bank of India, my lord.
And where are the
May I just assist, Lordship?
I don't know. These are the ones which have been served. Those are from the impugned order dated, as I understand from the papers, dated 30th of July 2026.
Lordship, the issue here might be a little wider because there's a maintainability issue also.
This is arising out of some order of 23/7/26.
And this is
Yes,
30th
Lordship.
July 2026, which was served upon Reserve Bank of India, my lord.
Would Lordship bear with me for a few minutes? I am for the petitioner.
Lord, there is an issue of maintainability. There is no, Lord, he is not a party to the writ proceedings which were disposed of. There is no application for leave to appeal, Lord. The appeal does not lie.
Lordship may have to hear me first because I haven't laid out why
But
I'm
it's a
here,
preliminary
Lordship.
point. It's a
And
preliminary point.
Yes,
I'm
sir, mine is
raising
a
that the
preliminary
appeal is
point too,
not-
that the order couldn't have been passed, Lordship. And we have served RBI. I say that on instruction. So if my learned counsel for RBI hasn't received it, she will have to find fault with her client.
Sir, these 3 mat on which organization, with Department of Reserve
Yes,
Bank
where
of
is the
India?
No, it's not about department. We know the RBI. There is no such thing as a department. But you can get those details. We'll give it to you again. That's not a problem. But duly served, we will share the email with you while the hearing is going on.
We have a copy. We'll give it to you
Yes,
right
you can give it here and now.
You have served them,
Right now, absolutely.
to give us the evidence of service.
May I, Lordship, then just place before Lordship what is the issues for consideration?
Article that I will not do. This is one and
Piyush, madam ke diye dao bhai.
Yes, sir. We're just handing over.
So now you have it.
I have to go through it now.
That's okay, Lordship. The RBI has no role and we have no prayer per se against the RBI. Our case is that the RBI has been made a party only to manufacture the writ jurisdiction.
Right. Maybe some.
Our case is exactly nothing to do with RBI.
My Lord, would
In
your
fact, we are
Lordship
in appeal.
permit me to take the preliminary point first? The preliminary point has to
May
come
I,
first.
Lordship? I have a
There
preliminary
can't be
point
an
on
appeal.
maintainability.
Lord, there can't be
I
an
have
appeal by
something
a
to point out,
non-party.
Lordship.
It's well
May
settled
I?
by the Lord, Supreme Court.
Please let us see the order.
Very
Just-
good. Very good. Your Lordship will do that.
Para 6, Lordship, maintainability is challenged. Para 9 is the issue, Lordship. Our problem begins from 16.
Yes.
So, Lordship, may I just briefly let Lordship know in no more than 5 minutes what is the background, what is the list, why am I here? And because I can refer to
Totally
several
irrelevant,
documents.
but the appeal can't lie at the behest of a person who is not a party to the proceeding.
For the court,
Lordship,
But
Lordship
I
may have
have
to
the,
hear me.
I'm
That's
armed
an
with the
incorrect
judgments,
argument.
not I can place it, but it's a preliminary objection. I leave it to your
It can-
lordship whether your lordship will
It
hear
can
him.
be
or
heard,
something.
Lordship, no problem. My learned friend can certainly place it later. See,
Yes.
Lordship, just 2 minutes. What is the
Locus. So tell us.
Yes, of course, Lordship. I'm going to point out that there is an issue. Why
Yes.
the Honorable Court and the learned single judge should not have passed the order. I'm going to therefore make good my submission. They are going on a technicality that I'm not the director. The cause of that is all pending and is finally pending before the Supreme Court. Lordship, this is the larger Birla Lodha dispute, which has been going on for over 2 decades. This goes back, Lordship. This is one of those wings or one of the legs of that dispute. In no more than 5 minutes, there is an original will between the late Priyambada Devi Birla and Madha Prasad Birla in 1982, a mutual will, where they said if one passes away, the other will get the property. And if when both pass away, it'll all go to charity. Somewhere in 1999, there was the late Mr. R.S. Lodha, who was the chartered accountant, confidant, closely associated. A will is allegedly made. In 2004, a codicil, and Mrs. Birla died in 2004. This led to 2 testamentary suits, one on the 1982 will, this is just the brief background, and one on the 1999 and 2004 will by Mr. Lodha. These matters have been going on. It goes back to the essential point. Where is the estate going to go? Now, the estate of the Birlas was divided into 3. There was an investment company. It used to be a drop-down basis. They owned shares in an investment company. Investment company owned it in a second investment company, which is tier 2. There were a set of charitable societies, and everything finally came down to the manufacturing companies. The companies which are before Lordship are subsidiaries of one of the manufacturing companies called Vindhya Telelinks. So this is the larger list. What is the reason why we are here will now become clear. In that, Lordship, critically, there were 3 stages of development, and why it's relevant to this, I'm just explaining. After Mr. Lodha passed away, there was both sides filed for appointment of an APL, Administrator Penente Lite. Eventually, in 2012, this court appointed an APL headed by a retired judge. It's either been a Supreme Court judge or a former Chief Justice of the High Courts. Currently, it is Justice Mohit Shah. There have been several in between. In 2000, now is the list. In September 2020, the learned single judge, because the fight after the appointment of the APL became on the powers of the APL and the extent of the estate. This is the crux of the issue. 2020, the learned single judge of this court holds that Mr. Harshvardhan Lodha, who is the son of the late Mr. R.S. Lodha, would not and could not be on any of the companies of the Birla, which is VTL, which is one of the companies here. He was in effect removed from being either a trustee of the societies or a director chairman. This is where the list begins now in this particular case. In 2021, these 3 companies are there who are before Lordship. There is a company called Insilco, August Agents, and Lanceda. 3 companies which are fully owned subsidiaries of Vindhya Telelinks Limited. They implemented the directions of the APL because the administrator Pendente Lite pointed out and told everyone across the spectrum, including the manufacturing company, including these subsidiaries, you will not take any decision without consulting us, because the estate now vests with the administrator Pendente Lite. in terms of the Indian Successor Act. Now, Lordship, this has gone to the Supreme Court several times. All that is final. In this particular case, when this decision came, parallelly, Vindhya Telelinks, which is, I would say, put it bluntly, in the control of Mr. Lodha, moved an EGM to say they will like to appoint new directors. So the persons who are before Lordship now are the original directors who were directed by the APL that you will not take any decision pending a clearance from the APL. This parallel EGM is the start of the dispute, in which 3 directors get appointed and directions are given to the bank, being Axis Bank, for change of the signatories. So, Lordship, this is where the actual dispute starts. As a consequence of this, these directors, who were the original directors and who had been asked by the APL that they cannot take any decision without clearance from the APL, moved the registrar of companies, and the registrar of companies marked it as a management dispute, subject to them approaching the competent court for an order of the court. So consequently, the directors who are the appellants before Lordship moved the NCLT. The NCLT, Lordship, gave a split verdict, one side accepting the plea and the maintainability, the other side saying no, got referred to a third member. Ultimately, the NCLT ruled against them, against us. Now, this was on the issue of maintainability. So therefore, the maintainability issue was ruled against us. The appeal was filed, is pending before the NCLAT. Now, Lordship, just for a moment, the NCLAT, which is seized of that matter, has kept it sine die, and that order is available. In effect, it has been postponing it, Lordship, because the core issue is pending before the Supreme Court, which is again going to be heard tomorrow. Let me come back, Lordship, to the list. Thereafter, Lordship, the MCA, being the Ministry of Corporate Affairs, unmarked the management dispute. So the Birla side went to the NCLT after the marking. Meantime, the MCA unmarked the dispute, and this side, again the Birla side of the directors here, immediately filed a writ petition before Calcutta High Court. It is pending even today. So therefore, Lordship, the root of the matter in terms of the removal of the directors, as also the fact that whether directions could be given to the bank, are both pending in 2 separate forums simultaneously in different natures. One is pending on the original marking of dispute, which is before NCLT, LAT. The other is pending before this court in the unmarking of the dispute. Now, in this background, Lordship, what happens is, and here the actual dispute starts. The other side, Lordship, came before the learned single judge. And when they came before the learned single judge, they basically sought a direction to say that Axis Bank must go ahead and deep freeze the account. How did the account get deep frozen? Because both sides were writing to the bank. Our side, if I may use that, in terms of the 3 subsidiaries of ETL, who are the appellants before Lordship, they had written freeze the account in this situation. So the other side, which are the newly appointed directors, they approach the bank and say, defreeze it. The learned single judge, in the original petition being 6088 of 25, in which there is an appeal today finally, Lordship, permitted the defreezing of the account. However, the 3 appellants before Lordship today were not parties. Would Lordship like me to pause for a minute? Am I going too fast?
No.
May I continue? I'm grateful, Lordship.
Yes.
So, Lordship, so the learned single judge, by a order of 9/4/2025, passed an order, in effect, defreezing the account, subject to VTL saying that, yes, we will give a indemnity. Now, this was done behind the backs of the 3 appellants who are the original directors, whose removal is pending before this court as also the NCLAT. Now, Lordship, they immediately, since it was passed behind their back, they sought impleadment, as in the three appellants before Lordship. Simultaneously, the bank sought clarification that who will be the authorized signatory from the original batch, the directors or the new directors. And the other side, the new directors filed a contempt to say that the bank is not complying. This led to the order of 19/6/2025, in which the impleadment was allowed. Now, Lordship, 19/6/2025 in effect stays the order of 9/4/2025 of the single judge, and 19/6/25 permits the impleadment. As a consequence of this, the respondents herein went to the DB, and the DB Lordship passed an order on 5/1/2026, in effect remanding the matter back to the learned single judge. However, gave a large number of findings or observations which would have an impact on the larger lists. Therefore, this was challenged and went to the Supreme Court, which the three appellants before Lordship, they challenged it. And finally, Lordship, the Supreme Court on 11th of May 2026 basically said the single judge may proceed without being influenced by the observations in the DB's order. Hence, the matter came back to the learned single judge. This is of relevance, which is where now the impugned order comes, Lordship. This is the mapping of the entire issue. Just one last leg. I pointed out, Lordship, that in 2020 September, this Honorable Court passed an order saying Mr. Lodha can't be on the boards, cannot be on the charities. Consequent to it, it wrote to everybody saying you will not take any decision without consulting us. In that, Lordship, that matter went to the DB. DB, in effect, passed a judgment on 14th of December 2023. That judgment, in effect, if I may say, looks at the larger gamut of issues, including the learned single judge's 2020 order, and basically passes a large number of findings on matters relating to control, the extent of the estate, etc. That is pending before the Honorable Supreme Court, which is the SLP of Arvind Kumar Nevar versus all of them, and that is listed tomorrow. So, Lordship, now to pause and start building my arguments. The first point is the larger issue with regard to the directions of the learned single judge, which the DB in a sense has overturned, is pending consideration because it all comes down to the administrator pendente lite, the extent of the estate and the power. That is listed tomorrow. Simultaneously, the directors who acted in consonance of the directions of the APL, who are the appellants before Lordship, their due process of the marking of the dispute, which the ROC did, is pending before the NCLAT, which is keeping it pending before the Supreme Court finally hears it. And the third leg being, Lordship, the unmarking which the MCA did, on the basis of which the other side is proceeding, that is pending the challenge before this Honorable Court. They are all intertwined. So where we are aggrieved is the learned single judge, in effect, has now passed directions that have far-reaching implications without consideration of the wider gamut of issues, without consideration of the issues that are pending, which go to the root of the matter. So the first legal submission, if Lordship would permit me to say so, is essentially, Lordship, that if the foundation is weak or collapses, then automatically the superstructure on which the respondents are building everything will collapse. That is, Lordship, that famous phrase of Latin. My first paper. Yes. Which is, Lordship, the sublato fundamento cadit opus, which is if the foundation collapses, the superstructure collapses. The second point, Lordship, is the argument of maintainability. there is judgment and law to the effect that Axis Bank, which is a private bank, will not be under the directions of an Article 12 state, which is why I argued at the preliminary threshold that RBI has been made a party to overcome the requirements of the writ jurisdiction being invoked. The actual direction should have been against Axis Bank, and through the writ, they are getting an order. Then, Lordship, the third leg being, my learned friends have my argument is, Lordship, that the root illegality doctrine will come into play. The root illegality doctrine being that if the starting point, which is also linked, if the foundation collapses, the superstructure will collapse. But if the foundation point or the starting point or the point of initiation is tainted or questionable, the subsequent actions cannot survive, and they certainly cannot be in the nature of directions that will be final in their application. This is the third leg, Lordship. And last, Lordship, is that in fairness, 3 points in relation to the order, and then if Lordship permits me, I'll go through the order and the documents, is that the learned single judge, Lordship, did not consider these aspects. And in effect, Lordship, while the issue of who is competent to pass the directions, as in the directors who were acting as per the APL, and whose list is pending before the NCLAT and in the larger list before the Supreme Court, as also before the Honorable Calcutta High Court, when they have challenged all this, can they be given a final finding by the learned single judge that they cease to be directors? When the adjudication is not before the learned single judge? When the learned single judge could not have adjudicated on that issue in terms of the pendency before the NCLAT as also before this Honorable Court. And therefore, she has held right at the threshold, they cease to be a director, which is where my problems begin with para 19. Second, Lordship, what the learned single judge says is that observes that the date when the writ petition was moved or the application seeking intervention was filed, they were not directors. Respectfully, Lordship, the learned single judge has erred. She has gone to the consequence of what we term as an illegal action without first bearing in mind that why we were necessary parties and our interventions should have been there. Third, Lordship, I have already said that if the authority of the purported directors goes by adjudication, which is the respondent side, if their very authority does not survive, it is an irreversible situation of the actions that they are doing today. Because it will impact even what is being considered by the Honorable Supreme Court in terms of the extent of the estate, as also the control that the APL exercises over that extent. So the directions that are today passed by the learned single judge are irreversible in the long term. And this board, if it is held to be an incorrect board, which is under consideration in terms of what I have argued, they cannot do anything that is irreversible. Now, this has wider implications beyond the company, because then this order will be used pointing out in other legs of the dispute that no, we have succeeded and got an order from the court, and hence this is an adjudication on the larger issue, which normally happens, Lordship, as counsels, we also do that. And this will be the necessary outcome of that. Then, Lordship, we have raised the plea of maintainability consistently. That has not been adjudicated. In effect, it has been cursorily dismissed. The last is, Lordship, all of these issues are questionable issues of both fact and, Lordship, law concerning the directorship. And Lordship, these are all pending before various forums. Please mark, Lordship, what is critical is the marking of the dispute was in 2021. The demarking was also in 21. And since then, the accounts are inoperative. So it is not as if these accounts have been in the daily use. These accounts have been inoperative with effect from 2021. There is no such grave urgency for it to have been defrozen when the larger issue was pending. Second, Lordship, the application, they have filed an application for appointment of receiver in the civil court, seeking documents. They have filed criminal things. There is a whole mesh of various issues that are there. All of these clearly evidence that the dispute is widespread, involves several issues of questions of fact and law, and it couldn't have been summarily dealt with in the writ jurisdiction. These were my preliminary sort of submissions, if Lordship. Now, these are my submissions. Now, if Lordship permits me, I will go to the order and show some documents to make good what my submissions are on. I am in your hands, Lordship, based on what you say. And Lordship, my core point will also be that Axis Bank cannot, be amenable to a direction under the writ jurisdiction. I have judgments to that. All of them are in the court.
That you have already said, yes.
Yes, I have judgments to rely and some documents to show. That's why I thought I'll place this.
Since I've been drawn into irrelevant things, let me dwell on that for a minute. Mrs. Birla never held a single share in this company, which has filed the writ petition. Never.
Before Mr. Mitro, could I just take that point of maintainability and leave it at that for the time being? Because these merits can be gone into, but not if the appeal does not lie at all. This situation is different.
Yes.
The merits can be gone into. Now it is well settled.
The parent order of 9th April, can you see the memo of appeal? Can you see the memo of appeal? It is only from the order of July 2026. That is the order passed on 23rd July.
23rd July, yes.
Only that order, Lordship. That order is after 3 rounds. 9th April, where the court held that there is that writ petition is maintainable, and that order has been is not under a challenge here. Thereafter, my lord, the learned now in the present order, Lordship, kindly comes to paragraph 16 of the present order.
Paragraph 16.
1/6 of the memo of appeal. In the order, the internal page 5 of the order.
Yes.
Upon hearing all the parties and on the basis of the documents on record, it appears that the very complaint which the applicants alleged to have been filed before the bank has, for reasons best known, not annexed to the writ petition. No submission on that. Matter of record. Next, the reason for not annexing the complaint, but as setting out the contents of the same in the application, is not known to the court. Copy of the complaint has been handed over to the court by the learned senior counsel representing the writ petition. It appears therefrom that the complaint was made by the company, that is us, writ petitioner, signed by the signatories at that point of time. The applicants never filed any complaint in the individual capacity. No submission on that. It's a matter of record. And this is also the division bench finding earlier. The company information downloaded from the portal of the MCA on 1st July 2026 has been placed before this court, wherefrom it appears that the applicants are not currently the directors of the company. Matters of record. And in fact, these persons, the MCA portal will show that these individuals have ceased to be directors in 2021 and 2022. 2 of them by retirement by rotation, retirement and not being reappointed on after the retired by rotation, and 1 at an EGM. So now coming back to, so on records of MCA, this is the position. The averments made in the applications and by the company law board petitions, NCLT petitions, are not by any of the applicants. Not by any of the applicants. The averments made in the application seeking intervention that the applicants are the existing directors of the petitioner company appears to be an absolute false and incorrect statement made on oath. Whoever filed the section 241 application made a prayer challenging this removal. The NCLT did not dismiss the petition from that NCLAT appeal is pending admission. The only order passed is will be listed for admission, not even admitted. I will show that order. That
My lord, sir,
not
I'm
even
sorry to interject.
please.
Your lordship was hearing on
Because
maintainability on, no,
because-
we were addressing only on maintainability.
Paragraph
My
21.
learned friend is going to address
Paragraph
on merits. You
21.
kindly hear us also on merits.
Kindly come to paragraph 21. The applicants
That's
may
a fair point, Lordship.
the applicants
That's a fair
may
point.
have been the director of the company at some point of time, but the date when the writ petition was moved or the application seeking intervention, they were not the directors of the company. There may have been disputes between the directors of the company. There are judicial fora where such disputes are to be adjudicated. The said dispute is not a matter to be decided in the that was Mr. Kohli's submission also. The court is of considered opinion that the applicants at this stage do not have any right to intervene in the writ petition. When the writ petition has already been disposed of, their recalling application, I mean, their intervention application come recalling. At the initial stage, they were partly successful. They were allowed to be intervened, but that order was set aside by the division bench. Set aside, Supreme Court has not interfered with that. Order set aside. And there was also a order passed that we shall not proceed with the contempt. Set aside in appeal.
So prior to this also, they had made an intervention
They
application.
filed this intervention application earlier. On the first day, there was an order allowing the application for intervention. They were added as party and there was an interim order passed. That order, we went up in appeal. The appeal court set aside that order. Lordship kindly comes to page 690. 690
Of
it starts at page in the which volume? 669 it starts. That volume.
669 of
The stay petition. The order has been set aside in appeal. 669. As Mr. Kohli said that there are many findings in the order, but the
Lordship, respectfully, Lordship, I have not argued on merits. My learned friend had raised a point on maintainability. I mean, this. And then I must make my case, Lordship, on merits.
My friend argued only on merits. He has not addressed maintainability.
No, I gave a background and I was about to start. I mean, therefore, how can
My
I
learned
not
friends
finish
did
my
not argue
arguments?
maintainability. I'm very
No,
sorry.
Lordship, their argument was on maintainability with respect to Mr. Bachawat, who is senior and elder to me.
See, the order of the learned single judge is confined to an issue of maintainability. He is only reading from that order. Now let us see. Please, you have made your submission.
I'll wait. I'll wait then, Lordship. I have something to say.
You are referring to 669.
is the order from in appeal from the earlier order of 19th June 2025. 19th June 2025 passed in this writ petition was not challenged, was where they was not annexed. Well, they had a copy of the 19th June order passed earlier in this writ petition from which the appeal was preferred. The 19th June 2025 order. 19th June 2025 order passed in this very application now, which has been finally disposed of. This was the order before the appellate court. Application for recalling has been filed by the applicant, not parties to the writ petition from which contempt has arisen. Grounds for recalling the order are that the necessary parties were not in. Yes, sorry. Paragraph 2. This is what the wrong order. Oh, 9 sorry, this is wrong order handed up.
9/4/25.
19th June 2025.
So this is the wrong order.
19th June 2025 order. Barabar. 19th June 2025. This is the intervention application which is finally disposed of now. Which for recalling has been filed by the applicant or party petition. Grounds for recalling are that the necessary parties were not implemented as parties in the writ petition, and that the order so. Now, kindly come to paragraph 5. Paragraph 3. After hearing submission made on behalf of all the parties, appears that matter is required to be heard and application filed by Axis Bank. The contempt application against Axis
Which
Bank.
order you are referring to? This 19.6.
19/6/2025.
Paragraph 5.
Paragraph 5. The
Contempt application.
as the file against Axis Bank shall be kept in abeyance.
Yes.
Order of 9th April, that is the order which allowed the which dispose of the petition, shall not be acted upon by any of the parties. Paragraph 7. Leave for filing the application seeking intervention stands allowed. Applicants shall be formally added as party respondents.
So the very same applicants.
This very same applicants in this very camp. From this, the matter goes up in appeal, which is at page 669. Page 669 is the volume 5, 669, volume 5.
Yes.
This is the order under appeal, 19 June. Lordship, kindly come to the operative part. Paragraph 49 at page 690.
Yes.
Paragraph 49, setting aside the order of 19 June 2025. And then it's single judge requested to take up all pending applicants together as per the convenience by bench by disposing of the recall application of this 57 and certificate.
Yes.
So this is from this it goes up to Supreme Court page 699. Oh, one more thing. My junior rightly points out. May I show paragraph 45 at page 680. Though, of course, these are findings of the court. Paragraph 44. Lordship, page 20, page 688. The fourth line from top. Fourth line from top at page 688. That's the respondent numbers 5 to 7. They're the appellants here. Prima facie do not have any locus standi whatsoever to be implemented. So this was the finding of court. Now the Supreme Court has said be uninfluenced with these findings. File a recalling application.
Mr. Mitra, if you would also show para 43, the beginning, so I don't have to say it.
43, Lordship takes a look at para 43 also, Ballard. Para 43. Furthermore, the respondent numbers 5 to 7 have been denuded of the locus standi to interfere in the affairs of the company by virtue of the NCLT order, does not have any right to be implemented in the petition at all. Even the appellants. Even otherwise, in view of the division bench judgment of this court, that is the December 2023, in the testamentary matter, the estate of PDB has been restricted only to her direct shareholding and the incidents thereof, thereby taking the appellant number 2, where she did not have any significant shareholding, it is actually 0, outside the ambit of her estate to be administered by APL. Hence, the challenge of APL against removal of 5 to 7 is a cause of action espoused by the APL itself and not on behalf of respondent 5 to 7 in their capacity as individual director. But now 5 to 7 cannot piggyback on the APL's challenge. The other ground which paragraph 44 I had placed relevant part, and then paragraph 45 clearly said. Paragraph 45, even otherwise, the remedy of respondent numbers 5 to 7, if any, could at best lie by way of an appeal before the division bench against the parent order passed by the writ court, with leave to prefer such appeal. This is the Supreme Court's finding also, Supreme Court judgment also, having not been parties to the original writ petition. The law does not contemplate an application for recall simpliciter in a disposed of writ petition, particularly since the dismissal was on the merits of the case. No case of review under Order 47 has been made out in the recalling application, nor has any other justification been given to recall the order. Thus, we do not find prima facie any case made out for the impugned order, for the order impugned because of the court being passed. The learned single judge, while passing the impugned order of 19 June 25, merely recorded after hearing the submissions of the parties. It appeared to the court that the matter was required to be heard, unfortunately, without recording any reasons or adverting to any prima facie case made out for so observing, thus putting the parent order 9 April suspension by directing the parties not to act upon the same for the time being, as well as keeping the contempt of it. With utmost respect, and the last 5 lines of paragraph 47. Last 5 lines of paragraph 47. There is no scope of impleading or adding parties to a disposed of writ petition, since the writ court is no longer in season of the matter after disposing of the same. Thus, the addition of parties in a dead writ petition is contrary to the basic tenets of jurisprudence. Hence, in effect, one of the final reliefs sought in the recall application itself has been granted at the premature stage by adding 5 to 7 as parties to a main writ petition, despite the recall application itself having been postponed for hearing. Accordingly, para 49, this is allowed. Then 699 is the Supreme Court. The order is quoted, then paragraph 3 of the order. At page 701, paragraph 3. We do not find any error, not to speak of any error of law in the impugned order passed by the High Court. Paragraph 3. The High Court has made itself clear that it has not gone to merits, and the single judge shall decide all the issues or being influenced in any manner. Observation shall take up all the applications. And C2 and the para 6 is very important. And
para 5, Lordship may just see also. Para 5, Mr. Mitra can read.
It is needless to clarify the single judge shall decide that issue without being influenced in any manner by any observation.
In the observations in paras 30 to 48, Lordship, which has just been read before in detail, I just thought that's relevant to point out. Paras 30 to 48, respectively, of the order that my learned friend read. I'm grateful.
For hearing, and see to it that they are all disposed of within a period of 3 months from today. And that is very soon, the 11th May, that is next week. Thereafter, my lord, when the learned single judge hears the matter afresh, kindly see the order. He has not, in his opening submission, closing submission, midway submission, not been able to show anything wrong in the order under appeal. That they are not directors in all the public records since 21-22. That in this is subject matter of another judicial forum, NCLT, where they have been unsuccessful. Now, kindly look at one more order, which they are talking about, my appeal pending in NCLAT.
So, what are the pending applications referred to in this paragraph 4? Paragraph 5 of the Supreme Court order.
Paragraph 5 of the
Supreme Court order.
Yes, paragraph 5 of the Supreme Court order. Let me kindly give
what applications were pending?
Well, there are 3 applications. This is after being set aside the intervention of recall application, 1 application by the bank for clarification, and our contempt application.
And intervention, Lordship. Our intervention.
And now the banks, so of the 3, 2 have been disposed of. 1 by this order and 1 by the subsequent order of the same judge. The subsequent order of the clarification application by the bank has also been disposed of by the order passed on 30th July 2026. From which they have filed an appeal before another bench, and the matter, there's no order. This is disposed of on the bank's application. Kindly note paragraph 2. In the application, copy of the resolution of the company's meeting dated 10th May 21, disclosing the names of the signatories of the company is annexed. None of these are appellants. The petitioners agree, that is, agree that the names disclosed in the resolution of 10th May would be the signatories of the company. The bank is directed to take the necessary steps in the matter by permitting the signatories whose names appear in the resolution of the company meeting held on 10th May 21. So the clarification is disposed of. So the signatories have been changed. Now my contempt is pending, which has to be disposed of this week. So that has been only kept only because they kept insisting that my lord is hearing the appeal. The appeal has been filed, it's been listed today. So the order doesn't record that, but then that was the reason why it's to be kept on next Thursday. This will be kept on next Thursday. Now, my lord, they are opposing the contempt application. They're not parties in the contempt petition.
Yes.
They're not parties in the contempt petition at all. Now, lordship, kindly come to so this is the factual background. Well, so their locus, if any, seized in the 6 years back, 5 years back. And this has been held twice over, but they have not shown anywhere in the order which is wrong. She has talked about the estate of Mrs. Birla, how Mrs. Birla's estate comprised of APL and etc. What is in the Supreme Court pending from the APL order of the division bench passed in December 2023. There also, lordship kindly notes one thing: the Supreme Court, yes, in fact, appeal they're talking about. After all, the issue of the NCLAT appeal, the NCLAT order which went against, I would not say against them because they are not parties there, or maybe they are parties, but they are not the petitioners there. It was dismissed. From that, they said their appeal is pending before the NCLAT.
Yes, that was taken note of by the learned single judge.
Kindly see the order. They do not add. What is it kept pending for? Can I see the last line of the order? Second page.
What is the date? If you don't have a copy, at least get the date.
Copy the order. There's a copy here, no? Copy. Almost 3 years back, 12th October. List these appeals under the caption for admission after notice. They are taking adjournments on whatever grounds or whatever. I'm not concerned with the fate. So the NCLT order today is final. The Supreme Court's order from the division bench, judgment of Justice Sivagnan, 20th of December 2026. Supreme Court order.
See, speaking for myself, I don't have any idea about the background, apart from what has been stated by Mr. Kohli in his submission.
Because that is
relevant today. The order of
No,
the learned single judge is only on the issue of a locus.
that's a testamentary suit that is pending there. It is, according to us, it is not relevant. They are not parties to that suit also.
Yes.
My company, petitioners are not parties in that suit also. None of the parties here are parties to that suit also. So, well, how that is relevant? And anyways, all the orders presently in that suit also are against them. All the orders presently, which are subsisting. And Supreme Court has said there is no interim order, and the division bench order, there appears to be nothing wrong with it. So this is the position. Lordship kindly did not entertain this on the mentality. If your lordship hears them again on fact, then of course I shall respond.
Lordship, just before my colleague
before
starts.
Mr. Kohli, Milord,
Of course,
before Mr. Kohli, Milord, I have a far more serious point. Milord, take care.
Next Thursday.
No, because it has to be disposed of by 11th. 11th is next. 11th is next Monday or Tuesday, so it's been kept on Thursday, day after tomorrow.
Day after.
Milord, I will take exactly 5 minutes. Milord, no more than that.
11th of August is expiring on next Tuesday. So the learned single being alive to it has said I shall dispose it of before.
That is why we moved a stay, Lordship. That's why we moved a stay. Lordship, my learned colleague and brother.
But before
Mr.
my learned
Krishnaraj
friend,
Thakkar is going.
will not hijack my
No, I'll wait.
submission. My learned friend has made his submission. Now,
I'll
Milord, if
wait.
I could have my say.
Of course, I'll wait.
But
Yes.
5 short points. Milord, number 1, my learned friend's clients are not a party to the writ petition. Number 2, they are also not directors of the companies. Milord, the application that they filed, para 2 clearly says that they are directors of the company. They have not been for the last 3 years. Now, my learned friend may have some ground to challenge the order, he may not, but the point is he has come up in appeal where a non-party cannot file an appeal. The only way in which it can be done, and that's the procedure, right from the beginning of time till now, and I have the judgments to show your lordship. Someone who is not a party to a petition can only file an appeal provided he seeks your lordship's leave to file an appeal. There has to be a prayer for leave to appeal. Now, your lordships have to decide it before the appeal can be considered at all. My learned friend rushed headlong into it and he has pressed his appeal. But the fact is, without a prayer for leave to appeal, the appeal itself is not maintainable. Not I'm fortified by authorities on that.
Yes, we are only considering the issue of maintainability.
Yes, not the maintainability of the appeal. I'm on
Yes.
maintainability of the appeal.
Yes.
So, my learned friend, not being a party to the writ petition, cannot file an appeal.
Yes.
This is the proposition I am on. There are judgments, which I'll just my juniors, they will hand it over to your lordship. I'm down with a fever, so I couldn't be there personally. But if your lordship would take the judgment, please hand up Anjanappa's case. There are two authorities on this. One is going back much earlier, and then Anjanappa's case, which refers to the earlier judgment. Now, if your lordship would take this, this is a judgment of 2025. Now, here also the facts were similar. There was a disposed of proceeding. If your lordship comes to para Roman 8 at inner page 4 of the judgment. And in the first few lines, your lordship will find trial court upon appreciation passed its final judgment and decreeing the suit and granting relief of specific performance. Now, from here, my lord, if your lordship then comes to where this issue is dealt with, this issue your lordship will find law governing grant of leave to appeal, which is para 25. Your lordship will find a heading just before that. Law governing grant of leave to appeal. Now, if I may place from there, sections 96 and 100 of the CPC for short CPC provide for refereeing an appeal.
I'll take my, let's kindly. Second time, lordship is not taking up these.
Provide for preferring an appeal from any original decree or from decree to appeal, respectively. The aforesaid provisions do not enumerate the categories of person who can file an appeal. However, it is a settled legal proposition that a stranger cannot be permitted to file an appeal in any proceeding unless he satisfies the court that he falls within the category of aggrieved persons. It is only when a judgment and decree prejudicially affects a person who is not a party to the proceedings, he can prefer an appeal with the leave of the appellate court. So, without leave, this does not lie. And reliance is not placed on an older judgment of Krishnamurti, which I will also cite. Then, para 27, if your lordship comes to, a party to a suit adversely affected by a decree or any one of his representative interests may file an appeal. But a person who is not a party to a decree order may, with the leave of court, prefer an appeal from such decree of order if he is either bound by the decree or order or is aggrieved by or is otherwise prejudicially affected. Now, Lord, he is nowhere bound by the order over here. Now, having ceased to be a director, he is also not prejudicially affected. He may initially have taken some stand, but that was when he was a director of the company. Having ceased to be a director 5 years ago, he can have no locus at all. And then it considers not all the other things, considers party aggrieved and all of that. And your lordship may take para 36 once. para 35 and 36. The expression person aggrieved does not include a person who suffers from a psychological or an imaginary injury. A person aggrieved must therefore necessarily be one whose right or interest has been adversely affected or jeopardized. Now, no right whatsoever of these people have been not affected, who are not now today not associated with the company, and they cannot not seek to raise a personal grievance over here. But over here, if I may add one more comment, there is no independent challenge by these three persons to the fact that they have ceased to be directors. There is no independent challenge, no suit, no proceeding. So today he can no longer say he is a director. If he is not, then I would not respectfully submit that this is merely an imaginary injury, if at all. If at all. But thereafter, this judgment not considers all the other law and not comes to this finding itself, not which is really based on that not older Supreme Court judgment, which may not be necessary, but this is the principle. Now, Lord, if your Lordship looks at the prayers in their stay petition, there is no prayer for leave to appeal. If your Lordship would not take the prayers at page, but please just give me a moment. If your Lordship would take volume 1 at page 104. I'm sorry, Lord, I've got the wrong page, Lord. I'm very sorry.
Not claiming to have sought any leave, so you need not impress that.
Yes. So, Lord, this is the position. Without getting your, Lord, seeking your Lordship's leave, Lord, my learned friend cannot jump headlong and say, look, I have the right to file an appeal. There is none. The law does not recognize such an appeal.
Very good.
Lord, those are my submissions. Lord, if your Lordship thereafter chooses to not address this on merits, I'll make my submissions.
Ability only. We are not going to.
I appear for the appellant in the second matter. May I just reply on maintainability before Mr. Kohli reverts, madam? With the greatest of respect to the two learned senior counsel, can I see paragraph 43 of the judgment which has just been cited?
Yes.
This is an application. My application was for recalling an order and to add me party. The learned single judge dismissed. So it was twofold. Recall the order which you've already made in my absence and add me party and the writ of force. That order, that application was dismissed without deciding, recall, going straight to the second point, whether I should be added or not, which the Honorable Division Bench of our court has deprecated in that judgment which your Lordship was just shown. So, my lord, now the question is whether I need leave to appeal from an order rejecting my application for intervention. That is the short point. Kindly see paragraph 43 of this very decision. It covers it.
Leave decision, the Supreme Court decision.
Yes. What happened in this case was during the pendency of the suit, the subsequent purchaser made an application for addition of party under Order 1, Rule 10. That application was dismissed. He did not prefer an appeal. Now, this is the appeal which I preferred now, which your Lordship is considering. Where is the question of leave to appeal? Had I preferred an appeal from the original order, by which the petition was allowed in my absence, because I was not party to that proceeding, I would require leave to appeal from the original order allowing the writ petition. Today I am against because my application for leave to intervene and recalling has been dismissed. Therefore, I do not require a leave to appeal.
Yes.
Kindly see paragraph 43. It's very clear. So this is a bogey which has been created on maintainability. Now, my lord, and so much has been said that all these facts are irrelevant. They would have shown your Lordship that the whole writ petition proceeds on these facts. Kindly see the writ petition once. I'm surprised at the submissions which have been made. Kindly see, my lord.
We are not going into the merits at the minute. Only on the issue of locus, whether the single judge rightly held that you had no locus, then an issue has been raised that you have no. Your appeal is also not maintainable for not filing.
So, my lord, my appeal is maintainable without leave to appeal. That is my respectful submission. This is an application for addition of party and recall consequent that has been rejected. Appeal automatically lies because I am the aggrieved party. Paragraph 43 of Anjanappa says that. Now, my lord, on my locus, which the learned single judge has decided on, whether I have a locus to maintain that application. That is the other point which there with a group.
The submissions were advanced by Mr. Kohli. He has said there is a
That he was on online, he had some difficulty.
no. He was very
No.
very much loud and clear.
But I had no difficulty. He has highlighted the several litigation in the background, and he has brought to the notice of the court that there is according to him, a tangible threat that it will lead to an irreversible or irreparable
May I
injury.
just be allowed to supplement that? May I just be allowed to supplement that? I will not repeat anything which Mr. Kohli has already submitted.
Yes,
Now, my lord, kindly have their writ petition once, please, my lord.
we are not going into that. We'll
Because my-
move on the issue of maintainability tomorrow, and then if it is required, we'll ask.
But on locus, your lordship will kindly consider, because locus goes to the merits of my application itself. My locus is on the merits of my application. If your lordship kindly takes once the order, kindly bear with me for a
The
minute.
single judge has not gone into the merits. We will not travel into the merits.
My lord,
It is only from the point of locus.
Very well, my lord. On the locus, may I just trouble your lordship with one submission?
Please make a submission.
My lord, may I come back tomorrow? Or at 2 p.m., whatever is convenient. Or after that 2 p.m., your lordship has a fixed matter after 2 p.m.
We have a matter fixed at 2 p.m.
I know, I was just told that.
And
My lord, can I come back tomorrow?
no, we have heard.
Then, my lord, after your lordship finishes the 2 p.m. matter after its disposal, because there are two other appeals, my lord, and this is a final order which is made. That is why. Otherwise, I would not have.
PM, how many matters we have? Two. So after that, if we have time, we'll give you 5
Please.
minutes. 5 minutes.
Yes,
Yes.
Only
काट दिया उसने पहले चलो लीव कर दो उसको हाँ उधर से काट दिया उन्होंने
I'm for the appellant, my lord. I'm for the appellant in this matter.
Lordship, I appear for the state of West Bengal. I'm junior to Mr. N.G. Khaitan, the advocate on record. Lordship, may I please ask for service of the
Let's see, my lord. If they want a copy,
yeah, I
can
want
give
a
that,
copy,
sir.
Lordship, because it was served prior to the change in the office, which is why we are unable
And I'm
to.
aggrieved by the order dated 10th April 2026, passed by the Learned Single Bench, my lord. And this is an appeal against of a conductor of the bus. Now the urgency is, my lord, he is not receiving the subsisting allowances since this order is passed, and the dismissal order was confirmed by 10th April 2026. But kindly come to paragraph number 4 of this order. Learned advocate representing the petitioner submits that the petitioner ought to have challenged the amended standing order which permits the departmental head or his delegated officer to pass an order of punishment. Learned advocate for the petitioner further submits that the petitioner intends to challenge the amended standing order. The same is not under challenge in the instant proceeding. There is no further point which the petitioner raises in the instant petition. It appears that the final order has been passed in accordance with the service rule of the petitioner upon compliance of the principle of natural justice. The petitioner does not challenge the final order per se. The petitioner accepts the deputy managing director of the respondent authority had the jurisdiction to pass the final order in the proceeding. My lord, there was no order passed in that writ petition. My lord, my prayers in the writ petitions were, your lordship will find it from
No, what was,
970.
what was your prayer before the writ court?
Yes, my lord. Lordship, kindly come to page 26 of the stay application. Main application. Read in the nature of the mandamus directing, commanding respondent authorities, their main agents and subordinates to forthwith cancel, rescind the final order.
Where is that order?
My lord, final order is in page 46, my lord. Issued by the Deputy Managing Director, West Bengal Transport Corporation. May I read it, my lord? Third paragraph is the ground for refusal.
Yes.
So, my lord, I am aggrieved by this. But what has happened, my lord, kindly come to this order. The inquiry was conducted. Initially, there was a writ petition earlier filed in pursuant to the order of the Honorable High Court, Calcutta, 16/5/2024. Lordship, there was the issued by the managing director, and the subsequent proceedings as detailed in the company's record. It has been observed that an inquiry was conducted. The inquiry was earlier conducted was regarding the charge sheet issued to you, wide memo number such and such. The inquiry was conducted by Sri Anupam Vishwas, OSD ex officio, operation manager, who submitted findings on 27/9/2021 stating.
When we have gone through it, why you need to read again?
The only
What
thing
you are submitting, we want to know.
Two things, Violet. This order suffers, there was a reply. They took a point that it was not submitted by you, but it was true. By
Under which provision? Show us that somebody else can give a reply on your behalf. Just show the provision.
Well, there was no provision as such,
Then-
but why not the but
Anybody will say that I am giving a reply on behalf of someone, and the authority will
the
consider.
lawyer has done it.
Huh?
Lawyer has done.
How can he? Unless there is a permission granted for representation through a lawyer, unless the inquiry officer or the inquiry officer, presenting officer is a lawyer or possessing a qualification of LLB, how you can get such a? And that has never been done by you. You could have asked for a permission to be represented through lawyer. You
But
didn't
my
ask.
lord, that permission was not taken, but it was submitted. My lord, so
Can it
they can say that there were
cannot be.
points which were given by lord. And lordship, in those points, lordship, if those are applied, then your lordship will find
It is.
some different result, outcome of this entire thing. So lordship, consider that.
We don't know.
That is one aspect. Number two, my lord, so
Where
far
is the inquiry report?
my lord,
Where is the inquiry report? 27/9/21.
yes, my lord, kindly come to the chart sheet that is in 72.
We want to see the inquiry report. 27/9/21. 21/6/19 is the charge memo.
The page number, page number. My lord, once the inquiry report dated, which one, my lord?
It is of 27/9/21.
Written, my lord.
Anupam Biswas is the person who has conducted the inquiry. He has submitted a report on 27/9/21. You just read it at the second paragraph of the impugned order.
My lord.
Is it there in the record?
Page 104.
104.
104.
My lord, annexure M, my lord. Thank you. My lord. Lordship, And my lord, may come to paragraph page 106. The last but one paragraph, my lord. There was, Lordship, they had permitted the council.
No,
Defense counsel.
defense assistant. You were allowed a defense assistant,
But they have
not a lawyer.
Not a
You see
lawyer.
this term? Page 106. Last
In the same order, they have used the term assistant also.
My lord, page 105, there's an admission on his part.
105, he said, I will not repeat this in
Yes,
detail.
so
We have seen that.
he was given all the chances of hearing. He was given chances to reply. He did not.
Is there any rule barring the carrying of any cash by a conductor?
Yes, my lord, the conductors are generally allotted a certain amount of cash, which they are given the certain amount of allotted cash, and any personal cash that they have, it is deposited to the counter before they take on to the duty.
So they are not supposed to carry any
No,
cash.
so there is no issue of personal cash here. It's only accountability.
And since the tickets are so low price, this amount is huge.
My lord will yes, because generally, my lord, even my lord, on personal basis, I have seen, my lord, the buses which carry long distance routes, they generally take over passengers and do not issue tickets to them. And the number of passengers that are boarded on the bus without the tickets are huge in number for short distances. So this cash, my lord, is quite possible. And further, my lord will kindly comes to.
Where is your reply to the charge memo? Let us see your reply to the charge.
Well, there was no reply to this charge. Thereafter, the writ petition was filed, and the order was passed by the Honorable Justice Mantha, Division Bench. Where is that? Lord, you kindly come to page 90. Page 90.
No, there is some reply at page 77.
Page 78, last 3 paragraphs, my lord. There is one line which states, my lord, I want to add that there is provision in our departmental system that excess amount, if any, will be deposited to cash counter. But before the said stage, my bag was checked and seized, and the said amount is against your made system. I was carrying it. I was supposed to deposit.
No.
After the ride.
My lord,
After the ride.
I have to deposit whatever is.
Before you
collected, I
board
have
the
to
bus, you
deposit.
have to deposit, not after that.
But that I have said that rule. I have mentioned about the rule. My
Lord shows which rule says that after the ride you can deposit your personal cash.
lord. I find it from the reply, my lord.
It's not there. You are saying that before boarding the bus, you in a way what you're trying to say is before everything started, I was checked. But that's not a fact. You were checked near Esplanade. It was a bus going from Esplanade to Amta,
No,
and
on board they
on
came.
board the bus, yes. So before boarding, the bus, you are required to deposit, not afterwards.
But that rule,
at
my
the
lord,
counter.
Lord, you kindly come to the charge for which I have been dismissed.
So there
by
is
the
no denial of cash.
Lordship. Denial of cash was not. It was not denied. My lord, we contended there was violation of natural justice.
What is the punishment?
My lord, here, my lord, they have kindly come to page number 119. That is misdemeanor and discipline 12A. This is for theft.
What is the punishment, sir? We
Yes.
are asking you. What is the punishment awarded?
My lord, this dismissal is the highest punishment for theft, my lord.
What punishment was awarded to him?
He was dismissed from service.
Dismissed.
You dismissed him for having 700 rupees.
My lord, the reason is, my lord will kindly comes to page number 63.
You filed an opposition before the
Yes.
writ court.
Yes.
Where is
My-
your opposition?
My lord, my opposition starts from page number 51. My lord, in my opposition only kindly comes to page 63 of the.
So before, just come to the inquiry report. You have established the charge with reference to which evidence?
And he has admitted his guilt.
Where is that admission?
My lord, page number 105.
See, an admission means that yes, I accept the charges. He says,
So nothing remains after that. He's charged with excess cash. He says that yes, I have it and I will not do it again.
see, where is that?
My lord will kindly comes to page number
That
105.
is the recording by the inquiry officer. Where
But
is
he's
that?
not refuted that. He has admitted it.
Where is that in his reply to the charge memo? Come to his reply to the charge memo.
He has
That is the
not.
only thing on record.
My lord, he has not. His advocate sent
Come to
some.
the reply to the charge memo. So this is the second time.
My lord, this is not the second time. That is only that is what, my lord, I'm trying to demonstrate. My lord will kindly comes to page number 63 once. My lord, 63, 64 is the number of offences that he has committed. Every 2 months, offences are committed, and offense, and as well as 65, my lord. So he's been warned. He has been levied fines, and after so many offences, finally, my lord, he has been discharged from service. He's a habitual offender. He has admitted his guilt. He has been given opportunities to reply to the show cause, reply to the charge sheet, to call for defense witnesses, to cross-examine the witnesses. He has done nothing of it. He has filed 5 writ petitions. All the writ petitions dismissed. There was one.
Would you kindly come, sir? That is.
There was
page
one.
8.
There was one mistake by the respondent corporation that I should admit, that the inquiry report and the second show cause notice was not served upon him initially. For that, he filed a writ petition. And by the direction of this court, that also was served upon him, asking him to reply. He did not.
I replied through the London.
Not dealing with the charges.
Whatever reply you filed, where is it? How it can be looked into when you are not. Where is that?
Yes, ma'am. That's in page number.
Page number 97 is the report.
102. That is it.
That's it. solely on the ground of violation of principle of justice.
Now, where is the violation of principal justice if
That's
the
recorded by the
petitioner himself does not reply after giving repeated opportunities?
the same inquiry report was given.
There was no order to conduct a fresh inquiry. The only order was to serve the inquiry report.
From the perusal of the above order, second show cause notice, it is apparent that you have issued the second show cause notice only after you were directed to do so by the Honorable Court.
Yes.
It should be brought to your notice that such an admitted infirmity cannot be subsequently rectified. An order that has been passed by violating the principle of
And that order was never challenged before the
out and out.
the order was the order petitioner obtained the order from the court. He wanted it. He was also paid subsistence allowance.
And two witnesses were present at the time of the raid were not independent.
Why? Because they are of rival unions. This is the contention.
Yes, that shows that he was not independent.
Where's the final order of dismissal?
Final order
Oh, that we have already seen, 30th July.
107. The same person, my lord, who has conducted the inquiry, filed the charge sheet.
No, that also by the order of the court. And that has also not been carried up in appeal before the Honorable Court. And the petitioner himself wanted it.
You have not considered the past conduct in any order, neither in the final order nor in your inquiry report. You are showing us.
No, my lord, subject to correction, my lord, that has been
Show us.
mentioned. My lord will kindly seize the third last paragraph, my lord. It starts from upon reviewing the charge sheet.
Page.
My lord, page 107.
Yes.
The final order I'm reading. My lord.
There are only two instances.
No, after a thorough review of the case and considering the facts and circumstances revealed through the inquiry, it is found that repeated actions of possessing cash or in two consecutive
Third
months.
paragraph.
My lord, the third last paragraph. It starts from upon reviewing the charge sheet.
Yes.
My lord, here repeated action of possessing cash has been considered. And the court wanted to know about his antecedents, that which is why page number 63 was shown to the court.
This was placed before the writ court
Yes,
in the present proceeding.
yes.
How many instances in that?
Since 2002. Since 2002, my lord, he has been continuously found with excess cash or deficit in cash. And my lord will see the result column on the right hand side. Most of the time he has been fined, he has been warned. So from
So this record is only for him. It is maintained only with respect to a particular employee.
Every employee has their own
So this is only concerning
this is only
it's not a general record.
No. This is concerning him.
So all
Malad
of
will
these are
sees the Malad at the top of the sheet. Malad will see the name of the concerned employee, Ashit Kumar Chaulia, who is the petitioner.
It is maintained for all, my lord.
No, it
should
is not
be.
maintained for all.
Because conductors record head office.
Yes, and
So
this
they must maintain the records for all conductors.
no, no.
must have.
But this sheet is
This is for you.
yes, this is for
Okay.
the petitioner.
The point you asked before the single judge is that he's the same authority who has passed the order.
That is one point, my lord.
And my lord, that has also been my lord.
In the rule, but Lordship, the read court can exercise its power to test the validity of that rule, my lord.
That rule has never been challenged. My lord will kindly comes to page number 42 once.
That has been recorded by the learned.
Yes, by Justice Mantha.
You sought a direction for consideration by this authority. They have considered what is to be. He was the disciplinary authority.
Disciplinary authority.
So who else will consider according to you?
But anybody else apart from him, my lord, any officers.
So you are not challenging the competence of the authority. You are alleging a kind of bias against this individual.
Well, I'm not challenging. This is a rule, my lord. I'm not alleging. My lord, it's a fundamental rule, my lord, that that individual who is acting as the disciplinary authority must discharge its duty in an unbiased way and independent manner.
There is no question of bias here. That never has been challenged by the
Is this
petitioner.
the way you are responding to
I'm
every
sorry.
submission he is saying?
I'm sorry.
Continuously you have been doing this.
I'm sorry.
Yes. And he is respond number in the writ petition. Who is he? Respond number what in the writ petition?
Well, that is point number 6, my lord, subject to correction.
No, that is the inquiry officer. That's not the
Deputy
disciplinary.
Managing Director, respond of 5. Deputy Managing Director, West Bengal Transport.
He is the
Corporation.
disciplinary authority.
Disciplinary authority.
We don't point. Yes, take down.
Paragraph number 10 in the ground, Roman 10 of the stay application.
No. Where is the application of bias or malified in the writ petition? Again, we are asking.
Writ petition, right?
Don't show us an appeal here.
You will find. Writ petition, I
My lord, item number 2, my lord, I am appearing for the corporation. My lord, may I seek an adjournment in this matter? I need to get prepared, my lord. And
Let's see. Just let us see.
Affidavit of service limitation.
Yes, affidavit of service. You are for the appellant in this case. So who is for the appellant?
Item number 1.
Mr. Devdatta Basu is the on record, advocate on record.
None appears for the appellant. Stop.
One in number.
Yes, call the. There's more to PM.
Item number 29, my lord. My lord, this is that matter, my lord, where the virus of the rule is under challenge and where, my lord, the female candidates have been completely outstepped in the recruitment process, which was conducted by the, is still ongoing, my lord, by the Kolkata police authorities.
Have you recorded the facts in any order earlier or we have?
No, my lord. It's one my lord, order was recorded, my lord, where a plea was taken. Also, although not before lordship, my lord, it's a vacation bench. It was moved. It was taken that I am. This petitioner doesn't have a locus to move as he has crossed the age. My lord, that was also, my lord, I brought on record that I belong to reserve category candidate and I was 32 when this entire recruitment took place. I am graduate, so I fulfill all the requisite qualifications required.
Then on one day an issue was raised that you have participated.
Yes, my lord. Later on, it came to they have withdrawn the affidavit, my lord.
That it was someone else namesake.
Absolutely, my lord.
Yes.
Now, my lord, I may not. I just capitulate your lordship, my lord. But the recruitment process took place for the post of lady inspectress, my lord, sub-inspector of police, armed branch and unarmed branch, and my lord, Kolkata police surgeon. Now, my lord, with regard to
let's come directly to the advertisement.
Absolutely, my lord. Your lordship will find the advertisement at that page. Page, my lord, 30.
Yes.
Now, there's a table given, my lord. Your lordship will find these posts are to be filled up. Unarmed branch, my lord, that consists of sub-inspector of police, sub-inspectresses of police. My lord, I am eligible to participate here as a sub-inspectresses of police. But next is armed branch, applicable for male applicants only. My lord, this is where my lord, my right has been curtailed, I may say.
So for sergeant,
I'm the surgeon, my lord. Surgeon in Kolkata Police, applicable for male applicants only. Now, my contention is this, my lord, this two, my lord, total segregation of women officers or women candidates, my lord, by itself is, my lord, unconstitutional and violative of Article 14 and 19. My lord, your lordship sees the recruitment rule also speak of in the same language. It has also been annexed, which is under challenge. My lord, that is page 43. And my lord, subsequent, in terms of a lordship's leave, granted me leave to challenge the Kolkata, this surgeon's vacancy also. Initially, it was not under challenge, my lordship granted me leave. The supplementary was filed, and again, that was also challenged. Now, my contention is, completely, outstepping female candidates for the armed branch and the surgeon post. It's ultraviolence to the constitution. Now, my lord, your lordship will find your lordship has heard, my lord. I have to produce the judgments.
Don't rely on what you have argued earlier.
Yes,
the state council was not there at that point of time.
Absolutely.
So you have to make your
Absolutely. I will try, ma'am. Your lordship, can you take up page 30 once?
Yes.
Page 30, my lord, I may say this is the recruitment notice. Revised information to the applicants with the new vacancies, position, or online submission of application for recruitment to the post of sub-inspector, sub-inspectresses, armed branch, sub-inspector, armed branch.
What is the date of this advertisement?
My lord, that is sometime in 2023, my lord. I did not get the date. My lord, this is published in the, my lord, the website of the recruitment board. But it says your lordship will find it's sometime in 2023.
What is the last day that will?
My lord, that is my lord, window, my lord, your lordship takes a page 39 once. My lord, the last editing window, I may say, which was there. The editing window for 7 days will be given to the applicants who wants to rectify her personal information already submitted in the application form. The period of editing window will be on 24/9/2023, 1 hours to 39/2023 till 23:59 hours. So, 39/2023 is the cutoff for all purpose. Initially, I can make an application, my lord.
The application is 21/9.
Yes, ma'am. And the ultimately edit can be done. That is still, my lord, 30th of September.
It will not extend the time for application.
But it could be done. So, my lord, it is sometime in, my lord, in the month of September 2023.
Last date is 21/9.
21/9, my lord.
And recruitment rules, which is the relevant provision.
Now, my lord, if your lordship kindly takes up, my lord, the page 32 once.
No, recruitment rules is 32.
But it starts 30 is, my lord, the
Advertisement.
It
Yes.
starts from 30. And the recruitment rule, if your lordship wants to see, my lord, that is at page 43. My lord, if your lordship takes up the recruitment rule, my lord, things would be more clear if your lordship takes up page 43 once.
Yes.
My lord, this recruitment rule is, my lord, it's called, these rules may be called as Calcutta Police Sub-Inspector and Sub-Inspectresses Recruitment Rules 2023. Now, my lord, your lordship may just keep about the next page, my lord, page 44. Your lordship will find a tabulation form is there, my lord, for the male candidates at the top. Your lordship will find Sub-Inspector of Police, unarmed branch in Kolkata Police. Point 2, Sub-Inspector of Police in armed branch in Kolkata Police. So, my lord, being a male candidate, he can participate in both the unarmed branch and the armed branch. Now, my lord, B is for the female candidates. My lord, it's only for the Sub-Inspectors of Police in unarmed branch in Kolkata Police. So, my lord, with the armed branch is concerned, my lord, we have been completely segregated or outstayed. And my lord, third one is the transgender. My lord, I may not fall under that category. That is also confined to unarmed branch. Now, my lord, if your lordship takes up on page 45 once, the eligibility criteria.
So there is no question of claiming that you fulfill the eligibility criteria because there is no criteria for that post.
I don't have anything, my lord. I fulfill the criteria with regard to the, in sub-inspectors, I may say, yes, I do fulfill criteria. But
and there is a variance between the two in respect of male.
Yes, not there is a variance.
For armed branch, there is a different criteria.
Only one of the requisites are same. With educational qualification, age is same. Only the physical requirements are different, my lord. The physical requirements of one of the armed and unarmed branch, there is certain subtle difference, I may say. If we have been allowed to participate in the sub-inspectors of police, why I should be deprived of my right to participate if I fulfill all of the criteria, my lord?
Yes.
But this classification or, my lord, this recruitment rule completely outstepped us. Sergeant. My lord, with regard to surgeons are concerned, my lord, one recruitment rule was a supplementary application was filed, my lord. If your lordship will find a supplementary affidavit in terms of your lordship's direction dated 19th of January 2026. This is 2018 rules. Lordship got the supplementary affidavit, my lord. My lord, page 23.
The earlier rules.
My lord, this is the earlier rules. With regard to surgeon, my lord, there is no further amendment made. With regard to, my lord, this.
Annexure P8.
R8, my lord, P8, my lord. Your lordship will find next page. Page 34 at the bottom, my lord. My lord, your lordship will find 4 eligibility criteria for candidates. Roman 5. Lordship V, your lordship may take page 24. Lady candidates are eligible to apply for the post of lady sub-inspector of police in West Bengal Police and sub-inspectors in Kolkata Police only. My lord, this recruitment rule is called as the combined recruitment rules of sub-inspector unarmed branch, sub-inspector armed branch, and lady sub-inspector West Bengal Police.
How is this relevant to your claim today?
My lord, the surgeon rule is, my lord, 2023 rules amends, my lord, with regard to the sub-inspector's post. The surgeon post remains unamended from 2018. My lord, they were, my lord, your lordship will find
earlier for the constable also there was no. Sorry, for sub-inspector also females were not allowed.
Not allowed. My lord, branch part. Branch, my lord. With the armed branch we are allowed, unarmed branch we are allowed. For the armed branch, my lord, we are completely outside in earlier recruitment rule and in the present recruitment rule. And with regard to surgeons, my lord, this is the last recruitment rule of 2018.
Which provision was amended?
My lord. But the 2023.
Entire rule was, it was re-promulgated.
Yes, my lord. But the 2023 rules, my lord, speaks nothing about the surgeon. Surgeon remains unedited or, my lord, unchanged, I may say, my lord. And my lord, the new rules of 2023 came with regard to the surgeon regarding the sub-inspectors of police and sub-inspectresses of police in both armed branch and unarmed branch.
No, the new rule has excluded only in one.
My lord,
The new rule has excluded only for sergeant, armed branch sergeant.
yes, my lord.
Yes.
My contention is this, my lord. By, my lord, completely eliminating us. My lord,
So when the result was published?
result, still the examination is on.
Oh, it is ongoing.
Till date, my lord, I mean told, my lord, I also got the judgment, my lord. Initially, my lord, when the learned AGP Mr. Mukherjee was appearing, my lord, he took the plea that the results of the examination could not be complete because of the OBC thing, which is certain orders were passed by our court, my lord, which is assailed before the Supreme Court. Now, my lord, recently, my lord, I got the order, my lord, from the Junior Standing Council, present Junior Standing Council, my lord, that the pending matter before the Supreme Court has been withdrawn by the state, my lord. If your lordship, it's now been withdrawn, my lord, by an order dated.
So what you are saying is the earlier there was an impediment, now there is no impediment.
No impediment. Although, my lord, as of now, my lord, as per my instruction goes, no results were published. So question of, my lord, the entire process is not been complete. It's not been complete. No results have been published, my lord. The selection, I may say, is still ongoing. By an order dated 14th of July 2026, my lord, the state of West Bengal has withdrawn the special leave petition which was pending before the Supreme Court, my lord.
So what was decided which was challenged before the Supreme Court?
My lord, whether the OBC category personnels, my lord, who were inducted after 2014, whether their name could be, certain inclusions were done. My lord, our honorable court held, my lord, those inclusions are not in conformity with the rules or no my lord, proper, my lord, I will say,
so those who are held reserved under the 14, whatever it is, decision,
14, those are said to be, my lord.
Now the court has held that they are not.
Not. The earlier who are been
so prior to 2014, whatever it is, that will prevail.
That remains. So, my lord, that order has been the challenge by that order has been withdrawn by the state. So, my lord, our court's order stands.
So then, how those people who have applied as reserved, they will be treated?
I don't know, my lord. It's a big question, my lord. That is, but although the order passed by our court says, my lord, who has already got the benefit, they should not be disturbed. Now, these persons, I may.
But if they are already in the process,
they have not got the benefit as of now, my lord. I may say.
They have come out with any notification that all those who are members of those classes, they will now be treated as equal.
I have to seek
as unreserved.
If there is any notification, I'll have to seek instructions. I'm not aware of that.
14 July order.
No, because that substantially changes the entire recruitment process, assessment in the recruitment process. Because there are X number of applicants, out of them a particular number may be claiming as beneficiaries of reservation under the category, which now the court has held, as we are told, that they are not reserved category.
Absolutely, madam.
So how you are treating their application? You are proceeding with the same recruitment process, or you have given a notice that now they will be treated as.
That what is happening post this development,
because this is recent. This is of 14/7.
14/7, just a few days back. Just 2-3 weeks back, I may say, my lord.
No, why we are raising this issue?
I
We don't know if they want to proceed with this process, or they want to initiate afresh, or what they will do. because this will change the consideration of those persons altogether
in the ongoing recruitment
on the
process.
ongoing recruitment, because they are yet not beneficiaries.
No, my lord.
So they are not saved.
Absolutely, they are not safe, my lord.
As what you have told, we have not seen the judge.
My lord, I think my learned senior friend also won't disband.
So we are, because it is,
But this is something I have to.
it is not an
obtain,
issue
sir.
before us. Therefore, we accept what you are saying without.
I'll get it.
My lord, the thing is, my lord, as the selection process is on, my lord, at this stage, my lord, what I may beseech, my lord, if your lordship seeks, my lord, if they want to place those things on record, my lord, your lordship.
No, we just want to know whether they are proceeding with this or not. That's all. Otherwise, if we go through a hearing and ultimately they have decided
That is cancelled, my lord.
that we are going to go.
Then I will confine myself to the, my lord, the files of the rule. Then, my lord, leaving apart.
No, we don't know whether a new advertisement, how it will be issued, what they will do.
But the virus is, the rule is there. Now, even a new advertisement is issued, my lord, that will be in parameter or in terms of the present rules of 18 with regard to surgeon and 23 with regard to
But
this one.
this very recent development is likely to alter the outcome, or maybe likely to alter the ongoing process. We don't know what is the government's decision.
That's true, my lord. We also do not know, my lord, what will the outcome of those, my lord, who were earlier OBC, now not OBC.
No, and what will be the fate of the recruitment process which are still in the, which have yet to be finalized?
In the my lord, pipeline, who are the persons who are there.
Unless that judgment says that all those who are applicants now henceforth will be treated as unreserved, then there is no ambiguity.
Both will have to be, now it's been withdrawn, that judgment has to be taken into account.
Judgment delivered by Maharaj Tapalputu Chakraborty and Maharaj Rajshekhar Mantha. That bench, my lord, decided the issue.
No, is there any stipulation that all those who are presently applicants, now they will be treated as
far I can recall, my lord, the order says, my lord, those who have already got the benefit of this reservation, they should not be touched. No further benefit could be given to someone after the date of the judgment. So, my lord, if somebody has already joined a post, but he enjoys that post, then he should not be touched.
The entire roster will probably.
This is something different, my lord. They have not joined. Selection is on. If
what is happening in the other recruitment process after this withdrawal of the SLP?
This recruitment process is going on since 2023.
No, because
they
as
the written examinations and the papers are being evaluated. So now we've reached the fag, and now what is going to happen, Lordship? I'll have to seek instruction because this is only in July. What is
very recent? He's saying
14/7 order,
just.
My lord, I may say, my lord, another matter, my lord, before my lord Justice Ritopurja Kumar Mitra in a single bench, my lord, that was a recruitment of 2021-2023. My lord, they have taken a plea, my lord, of this reservation. And although that was prior to this order,
that stand of the state is now changed.
Absolutely changed, my lord.
They say we accept the decision of the division bench. That was wrongly, those classes were wrongly placed under reserved category.
Absolutely, my lord.
So now an issue arises, those who have applied under those category in an ongoing process.
What will the fate of those persons?
What will be the fate of those persons? Will they still continue with these advertisements? Will they go afresh? Will they come out with a general notice saying that since the judgment is there, now we cannot consider you as reserved? You will be treated as unreserved. We don't know.
Absolutely, that's true.
And whether this acceptance of the division bench judgment will lead to any recalibration of the roster, we don't know.
Likely there should be, my lord.
So there are so many issues which may arise,
Yes, my lord.
which may not also arise. We don't know. It is for the state to take a policy, how they work things out.
It's true, my lord. But although if this recalibration takes place in terms of the judgment, my lord, the 10% OBC quota remains 10%. That is not in dispute. 7% remains, but the persons who will be included in this 10% OBC A, there lies the difference, my lord.
So maybe it will be inconsequential that way. It may be inconsequential.
As because 10% remains 10% with OBC.
So that will remain 10%. Only the number who are trying to get into that 10%, that will decrease.
Say, I belong to certain caste who have been included after 2014. Now I'm being outstated. My lord, I may not be in 10%, but the 10% remains.
That remains. So though the others who were earlier already in that class, they will have more seats under the reserved category.
They will have to come into the general.
Their scope will be much more widened, my lord. They will get more, I must say, seek the advantage of reservation in a better way. My lord.
So you conclude your submissions.
Yes, Lordship.
We will ask her to take instructions and come back for her submissions.
Yes, Lordship.
Yes.
My lord, I have challenged the virus, my lord. Your Lordship knows. On the judgment of the Honorable Supreme Court, with regard to, my lord, this, my lord, completely sidestepping one, my lord, gender. I may say classification on the basis of a gender.
According to you, for this post, it is a complete exclusion.
Complete exclusion, my lord. This complete exclusion is, my lord, not permissible according to me, my lord. It's, in some cases, I may say exclusion is not absolutely bad. But, my lord, in this context, where I can apply for one post, post of sub-inspector, sub-inspectresses in the unarmed branch, why I should be, my lord, completely sidestep in the armed branch of the surgeon, my lord. My lord, similar issue fall for consideration.
So they should have excluded you on both posts.
No, I should be included in both posts, my lord.
That is the point. Yes.
No, but the similar situation cropped up, my lord, your lordship knows, in the judgment of, my lord, Babita Punia, where, my lord, initially, my lord, the government of India, my lord, allowed a two posts, my lord, for the, my lord, the female candidates for getting permanent commission. No, my lord, certain judgments were passed by the Delhi High Court, my lord, by the Honorable Justice, my lord, Sharjah Kishan Kaul, when his lordship was the Chief Justice of Delhi High Court, he passed in that order, my lord. It was assailed, no stay was granted, and it continued. Ultimately, my lord, in 2020, my lord, this was decided. Wherein,
Punia, what is the citation?
2020, 7 SCC, page 469.
Yes.
No, my lord, your lordship will find, my lord, in that judgment, what is a compilation given to your lordship.
Yes, yes.
My lord, I've relied on 4 judgments there. 3, my lord, I may say it's Babita Punia and allied judgments. My lord, all other 2, my lord, followed Babita Punia. And the other judgment is of, my lord, Anuj Garg.
Anuj Garg citation.
That is, my lord, 2008 3 Supreme Court cases, page 1. In this case, my lord, Babita Punia deals with, my lord, the armed personnel. In this case, my lord, by an act of the NCRT Delhi, my lord, the males below 25 years and all the females are, my lord, in a restaurants or my lord,
serving alcohol,
where alcohol has been served. My lord, the Honorable Court said, my lord, this classification is also not permissible. With regard to the female candidates, this cannot be done. With regard to male candidates below 25, and that is also replicated. This sort of classification, or not, on the contrary, my lord, the Honorable Court said the state should take steps so that something doesn't harm them. Or rather, the state should be more proactive in asking those to participate or to continue the job.
So rather than restricting, they should be protecting.
Protecting, my lord. This is the stand in the, my lord, the Supreme Court. If your lordship takes a Babita Punia once, my lord, your lordship will find. My lord, if your lordship takes up page 485, my lord, paragraph 28. Initially, I told, my lord, there are 2 posts, but thereafter, the union of allowed certain posts to be there for the officers to get permanent commission.
Yes, in that case, Apex Court did not have to pass any order.
No, my lord, certain orders were there. Thereafter, my lord, one paragraph where it is confined to say they would serve a staff appointment only. My lord, that has been struck down. My lord, the government notifications comes out. My lord, it confines them to certain posts, And it says it should confine, but if your lordship takes up. Again. So lordship takes up para 28 once. But this is during the pendency, my lord. It says during pendency of this appeal, the union government in the MOD issued a communication dated such and such for grant of PCs to SCC women officers in 8 arms of the services of the army. In addition to, my lord, initially there were 2, my lords, JAG, my lord, Judge Advocate General, and AEC, my lord, academic education part. AEC, which has been opened up for earlier PCs. The communication stipulates. Now, my lord, your lordship may skip, my lord, your lordship may straight away come to, my lord, 29.2, 29.4. The grant of PC, women officers will be employed in various staff appointments only in accordance with their qualification, professional experience, specialization, if any, and organizational requirements. Number 29.5. All women officers who are granted PC will continue to be part of their parent army service. They would serve only staff. They should serve on staff appointments only, both within the parent army service and in other fields of specialization. So, my lord, this word has been, my lord, completely struck down by the Honorable Court, which restricts, my lord, to those 2 and 8 posts. Now, your lordship kindly takes up, my lord, paragraph 87.87, my lord. These are the directions by the Honorable Court. My lord, your lordship got it, my lord. Paragraph 86. My lord, the directions we accordingly record the statement of the policy placed on the record of these proceedings by the Union government in form of letter dated 25 to 2019, my lord, that communication, and issues the following directions. My lord, your lordship may straight away come to, my lord, 87.1.5. The expression in various staff appointments only in para 5 and on staff appointments only para 6 shall not be enforced. My lord, 87.17 at this stage, opting for grant of PC, the choices for specialization shall be available to women officers on the same terms as for the male SSC officers. Women SSC officers shall be entitled to exercise their options for being considered for grant of PCs on the same terms as their male counterparts. My lord, thereby leaving no room, my lord, by which, my lord, the women officers are under the SSC to get permanent commission. Now, my lord, I may say, my lord, by these directions, I may say the entire field of, my lord, appointing the officers, whether male or female, in permanent commissions are being, my lord, made open. Now, there is no discrimination between them. My lord, if you lordship also, my lord, the reasons, my lord, page 85, my lord, the blanket restriction which has been given, that is also set out. My lord, but the fact remains also in this judgment, my lord, Bhavita Punia, that says, my lord, although, my lord, they should be allowed, but the parameters are to be required to be set by them. But I am not on the parameters. If some posts require certain parameters, my lord, if I do have, I can participate. But without having any parameters and completely sidestepping us, my lord, I may say it's not in consonance with the, my lord, the provisions of equality as enshrined in the Constitution. Now, my lord, the other judgment which I will be relying on, my lord, that is, my lord, the Anuj Garg. My lord, if your lordship will find in the compilation, other 2 judgments are there. My lord, they all deal with Bhavita Punia. Following Bhavita Punia, my lord, that is Annie George. One is Annie Nagaraja. Another Lieutenant Colonel Nitisha. Well, both the judgments follow, my lord, Bhavita Punia. So, my lord, I won't be troubling your lordships. Now, your lordship takes up, my lord, Anuj Garg, my lord, 2008, volume 3, page 1, SCC page 1. My lord, and if your lordship takes up, my lord. My lordship got it, my lord.
Yes.
21, my lord, equality has been defined. When in the original act was enacted, the concept of equality between two sexes were unknown. The makers of the constitution intended to apply equality amongst men and women in all spheres of life. In framing articles 14 and 15 of the constitution.
Which paragraph?
Paragraph 21, my lord. Equality, my lord, equality has been defined, my lord. My lord, got it, my lord.
Yes.
My lord, when the original act was enacted, the concept of equality between the two sexes were unknown. The makers of the constitution intended to apply the equality amongst men and women in all spheres of life. In framing Article 14 and 15 of the constitutional goal in that behalf was sought to be achieved. The same would not mean that under no circumstances classification entirely on the ground of sex would be wholly impermissible. But it's right that when a validity of a legislation is tested in the anvil of equality clauses contained in Article 14 and 15, the burden therefore would be on the state. While considering the validity of a legislation of this nature, the court was to take notice the other provisions of the Constitution, including those contained in Part 4A of the Constitution. Thereafter, my lord, the judgments have been quoted. My lord, your lordship may straight away come to my lord. The stereotypes has been mentioned at paragraph 41. Paragraph 41, my lord, stereotypes and roles, 41, 42, 43, my lord, these, I may say, that will come in my aid. Should I, my lord? Professor Williams, in the Equality Crisis of some reflections on culture, courts, and feminism published in Women's RTS, such and such notes, issues arising where the biological distinction between sexes is assessed in the backdrop of cultural norms and stereotypes. She characterizes them in a hard case. In hard case, the issue of biological difference between sexes gathers an overtone of societal condition, so much that the real differences are pronounced by oppressive cultural norms of the time. This combination of biological and social detriments may find expression in popular legislative mandate. Such legislation definitely deserves deeper judicial scrutiny. It is for the court to review that the majoritarian impulses rooted in a moralistic tradition do not impinge upon the individual autonomy. This is the backdrop of deepest judicial scrutiny of such legislation world over. Therefore, one issue of immediate relevance in such cases is the effect of traditional cultural norms, as also the state of general ambience in the society which women have to face while opting for employment which otherwise completely innocuous for the male counterpart. In such circumstances, the question revolves around the approach of the state. Instead of prohibiting women employment in the bars altogether, the state should focus on factoring the ways through which unequal consequences of sex differences can be eliminated. It is the state's duty to ensure the circumstances of safety which inspires confidence in women to discharge their duty freely in accordance with the requirements of the profession they choose to follow. Any other policy interference, such as the one embedded under Section 30 of the societal condition, will be opposite to the woman and against the privacy rights. No, my lord, I also, my lord, kindly, I also say the same thing, my lord. These points were also taken by the earlier learned AGP, my lord, that this surgeon post was a creation of the Britishers, my lord. It was only for the Anglo-Indians communities, and they require a well-built setup, and they have to fight it out in the streets. My lord, this contention was taken by the earlier learned AGP, Mr. Mukherjee. So, my lord, this even, I may say, my lord, this judgment in paragraph 42(3), my lord, makes it clear. This cannot be a ground to eliminate someone, my lord. And my lord, your lordship will find, my lord, paragraph, my lord, 46 and 47 once. Last, my lord, I will be showing 46 to 51, my lord, the standard of judicial scrutiny. It is to be borne in mind that
the scrutiny is stated in 50.
Yes, my lord.
But referring to 41, 42, 43, 46.
Yes, my lord. Everything, your lordship was dated, my lord. I won't be traveling myself. Your lordship was dated that, my lord. So, my lord, if this has been the situation, my lord, I may say, my lord, now, my lord, having these judgments and my lord, I may say, the equality as provided in the Constitution itself, my lord, doesn't debar me from participating in the selection process where the male can participate.
Yes, there can be no total or complete bar.
Absolutely not. I'm not saying, my lord, the state doesn't have the right to make, my lord, the minimum requirement standards that I have to be certain, I have to run certain, that state do have. But completely barring us on the pretext that I am of a different gender, my lord, that is against the equality under 14 and 15, my lord. Completely annihilating us from the, my lord, the recruitment process. My lord, I may say, my lord, although it's not there, my lord, Sudha Murthy, my lord, I heard an interview of Sudha Murthy, my lord, one of the founder members of, my lord, Infosys. Initially, my lord, she was also not selected for, like, she was a mechanical engineer, my lord, and she told that, I heard that thing, my lord, that I was the only engineering student in the entire campus. And my lord, at that point of time, Tata advertisement recruitment, and where only males were called in. She wrote a letter to the then Tata, my lord, JRD Tata, and my lord, she was allowed. Same thing, my lord, a mechanical engineer. Normally, my lord, we do not find women mechanical engineer at that point of time. Now, although there are mechanical engineers. But this, my lord, is completely against, my lord, the Article 14 and 15 of the Code. But this is my sum and substance. So, my lord, these rules which has been framed in 18 and 2023, which debars us, my lord, what is unconstitutional? And unconstitutional such, my lord, ultra-wise and be set aside by your lordships. This is my sum and substance of my contention.
Submissions.
Two PM. 2 PM.
17.
ठीक है. Instruction technique. The Supreme Court
7:30.
State is as bad. That is a submission. Found the judgment. Actually, we couldn't remember exactly, but
My lord wanted to get some clarification on the judgment, the matter of Nijma Khatun, which was delivered by Honorable Justice Dipankar Datta. With greatest of respect, this has no manner of application in our case. For the simple reason, I give you the background because I had some hand in the matter while it was constitutionally declared, my lord, that Madrasa Service Education Act was declared ultra vires by this division bench. From that matter went up to the Honorable Supreme Court. In the meantime, the madrasas, they went on giving appointment even without complying the rules which was there before the Madrasa Service Education Act. And they now wanted that it should be regularized in view of the fact that the Supreme Court was kind enough to upheld the MSc Act. Therefore, the MSc Act was upheld by the Supreme Court and said that in the meantime, the appointments which were made, that were also not made following the existing rules. Therefore, this has no application. Just kindly come to the basic factual aspects.
No, if we remember correctly, perhaps Jago judgment was considered.
And says Jago has application in the background of the facts of those cases. This fact does not tally with that.
Yes, you are.
My lord, may be pleased to my lord come to page 8 of the copy which is handed to your lordship.
Yes.
Certain questions were put by the Honorable Court to the State Council, then subject to answers to the aforesaid two questions. Being in the affirmative, what is the educational qualification of the petitioner and which post in which madrasa was he or she appointed? What was the staff pattern of the concerned madrasa in question? Both teaching and non-teaching staff, as on date the selection process was initiated, an appointment petition was made. Whether the permission of the relevant, this is very important, under the old rules, whether the permission of the relevant district inspector of schools was required for initiating selection process. If no, why? If yes, was it sought and obtained by the managing committee prior to initiating the process of selection? All the recruitments were made by the managing committee, not by any statutory body. Then my lord will kindly come to the relevant portion. He was, honorable judge was, the court was dealing with the respective cases. I do not trouble my lord with that. Now at page 13, it is important. According to the learned counsel, Mr. Ahmedi, Saidul Islam so and so were admittedly appointed after 14th March 2016, after this court had stayed the judgment dated 9 December 2015. This is one of the factors. He contended though several interim orders were made directing payment of salary to staff appointed immediately after section 8 and 10 to 12 of the MSc Act, that the Madrasa Service Commission Act was struck down by the single bench, no further appointment could have been made in terms of notification. Then 19, since the notification 1 and 2 was required to be followed by the managing committee of the recognized and high-aided madrasas, it would be worthwhile to note that relevant clauses, therefore, we should have a bearing on our process of decision making. Well, this is a very positive indication that what are the factors played into the mind of the Honorable Court. The appointment shall be made against a clear vacancy in permanent or additional post duly sanctioned by the competent authority. Now, these aided schools and madrasas will not, the sanction is first has to be approved by the district inspector of schools. Once sanction is granted, then the question of appointment follows. This was not done. The appointment shall be given after selection from eligible candidates through open advertisement of the vacancy. It was not done. These are the facts taken. Then kindly come to the next page, paragraph 5, selection committee. The appointment shall be made by the Madrasa Managing Committee, which will frame the norms and selection procedure at least 3 months before the written test and interview of the appointment in question. And the same is to be communicated to the office of the DR of schools, which was not done. Then paragraph 17, the state government in the Minority Affairs and Madrasa Education Department or the district inspector of schools concerned shall not take any financial responsibility for any appointment if made in violation of these procedures. These are the basic facts. Now, Lord, I just take your lordship, Lord, to the portion which the Honorable Court, Lord, had really referred to Jaggo. But it is specifically at page 24. The Honorable Court was dealing with case-wise. Then he was considering the case of Mr. Elias. Then secondly, the question of regularization in service does not arise in this case because the nature of breach that has occasioned. But in our case now, it is the government authority, they had interviews, they had public advertisement, and we have been continuing uninterrupted. This is not done by the managing committee or the particular of a college. This court in Jaggo and even in the most recent decision in Shukendu so might have taken a liberal view, but such views have to be read as confined to his own facts. Rather than laying down law which is binding under Article 141 of the Constitution, with due respect, I would again say the Honorable Judge will not, instead of making this comment, ought to have referred to larger bench if he was not agreeing to, but they proceeded. Larger bench or decision, the ratio laid down therein has neither been doubted nor diluted by any bench of co-equal strength. The principle of stare decisis, I am not traveling my lot with that. Therefore, this is the basic. I really do not trouble much because thereafter all the respective cases individually was considered by the court and said, no, you are not entitled to get the salary. They went up to the Supreme Court making application that we are working, we should be given salary. Then the court found you are working with whose permission? Where is the sanction given by the day of schools? Where is the selection procedure followed? With prior intimation of day of schools. Following this, this judgment was delivered. This has in my humble submission will not takes away the ratio of Jaggo and followed by two other benches of the Honorable Supreme Court. This judgment was specifically confined to the facts of this case, not otherwise. This is not a ratio. But this is my humble submission on this. The other submissions have been concluded. Honorable, I'm bullying this. May I take leave?
Lord, in my humble submission, Lord, this judgment, Lord,
They have said that in substance they are fulfilling all the four requisites as per Uma Devi's case. They have said they were appointed by a process, due advertisement. They are fulfilling the requisite qualification for holding the post. They have continued for more than 10 years without any aid of any court's order. And they have therefore said that they fulfill all the requisites as per Uma Devi's case. So on these facts, what is your stand?
Lord, my stand would be this, Lord, that they were appointed on contractual basis. Why contractual basis? Because Lord, Uma Devi, Lord, does not apply in their case for the reason, Lord, that there was no sanction post. Otherwise, they could have been, Lord, since after advertisement, they could have been appointed in a substantive post.
There is no sanction post.
No.
Where have you said that?
Because that's
where is that fact pleaded by you?
That's why they were given the contract.
Where that fact has been pleaded by you that there is no sanction post.
That if your lordship kindly see the impugned judgment, Lord.
No, you show it from your pleading. The judgment is under challenge.
Just a minute.
You can't show it from the judgment. This is a factual plea. We want to see where you have stated this plea. That there is no sanction post.
আমাদের রিপ্লাইটা বের করুন সেটে আমাদের রিপ্লাইটা হুম 151 great second volume
151
yes No, this is not reply. This is a document.
152.
This is also not reply.
কোনটা দেখছো WPST 121 121 page 152 page 152 lines second volume
এইটা
152 talks of creation of 20 posts. You are saying there is no sanction.
Kindly see 153 B. 153 B. All of them joined in the said post on the basis of the above said notification. It is specifically stated in each of the said notification as well as in each of the orders of engagement of the applicants that the said appointment is made on purely contract basis and their service shall automatically terminate after expiry of their present term, and that the said appointment will not confer them any right.
paragraph 6B page 153
There are two sets of paper.
two matters
Two matters
two WPST
121, 120.
This is WPST 121.
121.
121 of 2025.
Yes.
Now, your lordship sees 6B, that all of them joined in the said post on the basis of the above said notification. It is specifically stated in each of the said notification as well as in each of the orders of engagement of the applicants that the said appointment is made on purely contract basis and their service shall automatically terminate after expiry of their present term, and that the said appointment will not confer them any right and claim to regular appointment, absorption in any regular post of government services whatsoever. The applicants also agreed to obey the said condition and executed written undertaking to the effect that the said appointment will not confer on her any right and they will not claim to regular appointment absorption in any regular post of government service. Now, if your lordship sees, turns the next page 154, 154 paragraph E, second paragraph. Paragraph E, subparagraph, second subparagraph, the applicants were not engaged as per the norms of the said recruitment rule and also not through the Public Service Commission. Instead, they were engaged on contractual basis even after 10/4/2006. So their appointment also cannot be termed as regular appointment. It is further submitted that the state of Karnataka versus ML Kesti and others has clarified that the employees, though appointed irregularly but continuous service for 10 years or more before the cutoff date on 10th April 2006, when the judgment in Umadevi 3 was rendered and the state government or its instrumentality voluntarily accepted their services may be regularized provided they are found eligible for the post they hold. In the instant case, the applicants were engaged after the said cutoff date, and accordingly, the question of their regularization does not arise. Now, Now, kindly see paragraph 7, subparagraph D at page 155. With reference to the statements made in so and the state respondents deny and dispute everything contained therein, save and except what are matter of records. The applicants were engaged on contractual basis and their nature of engagement has not been changed when re-engaged subsequently. Moreover, initially they are getting a consolidated pay of so and so without any allowance, but at present their consolidated monthly pay has been revised and became so and so, to be enhanced at 3% every year on the basis of performance report as per model performance matrix by dint of issuance of an order dated 26 February 21 issued by the government. They were also provided with terminal benefits of rupees 3 lakhs after attainment of the age of 60 years. Therefore, they were never fitted in a scale of pay. They were given consolidated pay on contractual basis. They could not claim any regularization in any post of the government in substantive capacity. Now, this is the conditions of appointment and they furnished undertaking that they would not claim. Now, after retirement or in service, some of them have approached the tribunal for regularization. Now, if Uma Devi is taken to be, but it has to be taken to be the settled position of law because this is a constitution-bench judgment. Subsequent judgments that cannot be said to be overriding, cannot be said to have overriding effect over the judgment of Uma Devi for the reason that has been explained in an official liquidator case, 2008 Supreme Court. 2008 Supreme Court has clearly laid down the law that larger bench decision cannot be diluted by a subsequent division bench. The proposition laid down by the larger bench cannot be diluted by subsequent division bench judgment, even if the judgment is delivered today. That cannot, unless there is a larger bench. Uma Devi was decided by 5 judges. Now, that cannot be diluted. The Jago decision or other decision, Bholanath and other subsequent decisions.
Devi is a 5-judge bench.
Hunter. Uma Devi is a 5-judge bench judgment. That's why in 2008, official liquidator very clearly laid down the law that larger bench should always prevail unless that is diluted by a further larger bench. Because this is the judicial precedence, your lordship is aware. Therefore, your lordship, in another case, when I had the occasion to assist my seniors Lokhi Gupta and Joydeep Kaur in one matter, your lordship decided that since official liquidator is staring at the face, therefore, Jago and subsequent decision cannot be of aid to the petitioners praying for regularization. So I just show to your lordship the decisions rendered by your lordship, delivered by your lordship. But this is the single bench decision which was assailed by the petitioner. And in the appeal, my lords have affirmed the judgment delivered by the honorable single bench. Just but if your lordship kindly sees in the writ petition, which was decided on in the writ petition which was decided on 9th July 2025, in paragraph 31, if your lordship kindly sees the single bench judgment, paragraph 31, if your lordship kindly have a look. Paragraph 31. Have your lordship got it? Not paragraph 31 of the single bench judgment.
Just give us 1 minute.
Yes.
Yes.
Lord, in the single bench judgment, Lord, delivered on 9th July 2025, Lord, paragraph 31, if your lordship kindly have a look, paragraph 31. I'm just reading, kindly see, Lord, the strength of bench in the Uma Devi's case was 5. Hence, any deviation of the proposition laid down from the said judgment by any subsequent bench of lesser strength was heavily criticized by the Honorable Supreme Court in a judgment passed in Official Liquidator versus Dayanand and others. Reported in 2008, 10 SCC, page 1, paragraph 77 to 83, 90 and 92. Therefore, since Uma Devi still holds the field, unless the exception carved out by the Honorable Supreme Court in Uma Devi is fulfilled by the petitioners who are seeking for regularization, no other judgments can apply in aid of them. That is my only submission before your lordship. And your lordship, when this judgment was assailed, your lordship decided the issue. I have handed up the judgment of your lordships. I go by this judgment. The regularization was denied to the petitioner as well as the appellant.
So unless they fulfill the requirements as per Uma Devi, which paragraph 50?
53. 53. That is the exception. Right. Right.
One time settlement. One time settlement.
And your lordship, yesterday referred one recent judgment of the Honorable Supreme Court. Here also, your lordship would be pleased to find
31D.
Paragraph 31D, in Najma Khatun and others, petitioners versus State of West Bengal and others. Justice Dipankar, presided over by Justice Dipankar Datta. Kindly have a look. My learned senior friend, Mr. Bhattacharya, did not read the entire paragraph. If you will not, you kindly see paragraph 31D. 31D. We find no merit in such prayer. First, this petitioner has not claimed the relief of regularization in the writ petition. Grant of relief beyond the prayer clauses, though normally impermissible, could be considered in exceptional cases. This does not qualify to be an exceptional case warranting departure from the settled rule of no prayer, no relief. Secondly, the question of regularization in service does not arise in this case because of the nature of breach that has occasioned. This court in Jaggo, Supra, and even in the most recent decision in Shukhendu Bhattacharya Supra, might have taken a liberal view, but such views have to be read as confined to its own facts rather than laying down law, which is binding under Article 141 of the Constitution. State of Karnataka versus Uma Devi and Official Liquidator versus Dayanand are the larger bench decisions of this court. The ratio laid down therein has neither been doubted nor diluted by any bench of co-equal strength. The principle of stare decisis and Article 141 of the Constitution leaves us with no choice. Article 141 commands, and the law declared in Uma Devi Supra and Dayanand Supra binds all. Ratio, if any, laid down in the said decisions of benches of lesser strength is debatable, and we are not persuaded to follow the same. So this is the, I also rely on this. And therefore, since all the exceptional conditions carved out in Uma Devi's case was not fulfilled by the petitioner. This is all. Kindly. You as a Raj.
Grateful, my lord.
I'm extremely grateful to my lord.
Continue with item number 3.
The list of dates. Although I am formally briefed in item number 4, but your lordships have made notes in the brief in item number 3. So I'll just trouble your lordship with the item number 3, just to save some time. This is a index of the documents which are there in.
Not going into the merits, sir.
Well,
Again and again, we are,
No, I am not on merits, my lords.
we are confining ourselves to the scrutiny only to the extent the learned single judge's order is passed, nothing beyond that.
But then may I say one thing?
Yes.
First, we say in Bengal, my lord, the fact point. Consider fact point. My lord, the account was frozen on the basis of a complaint made by me.
That has all, see, now you are repeating.
No, my lord.
All this was stated
Clearly, that I was repeating and the freezing was removed. So
in addition to what he has said, for that we gave you 5 minutes, not to repeat what he has said. He has said all this. He has said that there is a gamut of litigation in the background. There are rights inter parties. There is a likelihood of irreparable injury being caused. Since 21, it has been frozen. There was no urgency. It was frozen on my complaint. All these things he has said.
I'm sorry, my lord, then I will not repeat. Two things, my lord. I just want. Two factors persuaded the learned judge to hold that I did not have locus in the impugned order. One was that management dispute complaint had been removed.
Unmarked.
Unmarked. My lord, the learned judge was not told that I had filed writ pending in this, which is still pending in this honorable court being heard by coordinate bench.
Plus NCLAT also. We have been told that also.
Yes. No, my lord, your lordship was shown one order of the NCLAT where the appeal admission was pending. There should have been furnished the current order, an order which was made at the time of filing. The current order shows it is agreed that his appeal will be pending till the issue is decided by the Supreme Court. Can you see that one order, please, my lord? I will only deal with whatever they've shown your lordship, my lord, nothing new. 3, 4, 4 papers were handed over to your lordship. Subsequent documents are already on record. I don't know why they did not.
Therefore, substantially, you are saying the same thing, that there are rights inter parties based on the various subsisting litigation. But that is substantially one and the same what Mr. Kohli has said.
Yes. Not just one decision then, because this is boils down to what is the right of a party to be implemented in a proceeding. Simple order 1, rule 10, what your lordships.
In reply, you are going to cite a decision.
But appeal 4.
Sorry. We have heard you patiently. This is not the.
But your lordships will decide on the text. With my respect, sir,
we have just repeated what was argued. And we don't think we have left out anything. So we will consider, we'll pass the order. Tomorrow it will be for orders.
I am in another appeal. I'll take 2 minutes. Will not repeat anything that has been argued either by Mr. Thakkar or by Mr. Kohli. 2 minutes, your lordship will bear with me, Lord.
Enough is enough, sir.
2 minutes.
Everybody is repeating the same thing. We can't do this all day.
Look, I will not repeat. I'll not even address your lordship on the aspect of locus. 2 lines from the impugned order.
Yes.
That I'll just show.
Please show. Which line you are showing? That order also.
That is, yes, that if you could just once have a look at.
Yes. Which order? See, he has laid stress on that finding, saying that it is likely to prejudice us. That also we have marked.
Yes, Milord, I'm not repeating that, so I don't even want to address your lordship on that. Something else I want to show to
We have heard everything. That's why we are saying you are
additional things, Milord. Two additional things,
There is
please.
nothing additional.
Just have a look at the impugned order once. Milord, one of the grounds that on which my locus was set aside or not considered to be adequate to be impleaded was the fact that I have written myself as a director of the company and I have not disclosed the complaint. Now, this was absolutely a stray line that was taken out of context because my application records that I am a director, I have been ousted. But that ouster is incorrect. One important question of law, not two. And I'll cite, we were not actually, the hearing happened in a way that we did not cite.
Don't say that. Don't say
No,
that.
no, I could not cite this.
You are led by a senior counsel. He was appearing. Don't say that.
That's a different appeal.
Now, if you want to be heard separately in reply,
no, Milord, what
we don't know of such a procedure.
Very well. That's all. I don't.
Still, we said all right. We'll give you 5 minutes.
So two aspects.
So we have given him. We are giving you. Don't try to re-argue the matter.
Not two aspects, Your Lordship will just consider. One is whether a complainant is a necessary party or not. I have decisions on that, but of course, propriety demands I won't cite it. The second bit is that there was an issue with regard to maintainability of the writ petition that was raised by us.
That is argued already by Mr. Kohli. That is argued by Mr. Kohli.
One thing that
the writ petition itself was not maintainable.
But one thing that
again we are saying here everybody is repeating the same.
No, what was that conduit I want to draw now?
Enough. Don't repeat. We will not allow you to repeat. Please.
Very well.
It is a pointless exercise.
You
have not said one thing which was not argued. So we have heard the parties. So one order, please.
Yeah.
Yes, call the next case.
Grateful.
Give your appearances. You give your appearances, all of you.
Number 6.
But I have to look at the observer. My Daniel friend is not here.
Not here. Not that. Not today. Not today. Not today. Yes. I don't know why all this is.
Number 7.
Number 6. Yes.
This is a case similar where the petitioner was terminated from service without any due process of law. Without any due process of law. Honorable single judge Millard held that that is illegal order, but did not interfere with the order. Order remained intact. And on the last occasion, the Lordship directed them to.
What did we direct?
May I clarify, Milord?
Yes.
There was a finding in the order of the Honorable Single Judge that there are no two minds that the petitioner had been deemed confirmed, deemed to be confirmed in service. There is no two mind to that. However, in view of the fact that national security is involved, we are not directing anything else apart from mere consideration. He was during the probationary period, which extended more beyond 2 years. He was terminated after that on the ground that his verification role was not up to the mark.
You refresh us tomorrow. We can't remember. Tomorrow we'll take it up.
Day after tomorrow.
Day after. Tomorrow with not today. It will appear with a note, not today, tomorrow.
Not today. না দরকার নেই দরকার নেই তাই হয় আর কি
Wait.
The matter relates to
Yes.
well, the matter relates to HRA, whether the husband
will get or not.
my lord.
So how you will get when you are living 47 kilometers apart?
But I have only 2 points, nothing more. That is the honorable single judge, my lord, inquired that whether any rent receipt is there. My lord, rent receipt is admittedly there is no such rent receipt. But what is there? Agreement paper is there because of my lord in the urban areas, they are making the 11 months my lord, tenancy agreement because of just to save themselves the creating right to tenancy, and therefore they are not no way, nowhere. If I get my lord, any rented accommodation, the rent receipt will not be issued. 11 months agreement will be done, and that is the license agreement, it is called. Just to avoid the creating tenancy right. And that agreement was there. On that basis, the husband was there. And my lord, they are saying that the distance between the my lord, wife and husband, that is 47 kilometers. My lord, my humble submission before your lordship that is, I have said that is the 50 kilometers and above. And they are saying that 47 kilometers, and 2-man inquiry committee was constituted. And I do not know how they have measured that is the 47 kilometers. There is no such basis. That is true. I have only 2 points. And they have admitted that my husband was resided there. This is the rented accommodation.
What is DPL?
We have never admitted.
What is DPL?
Durgapur Project Limited.
Durgapur Project Limited.
We are the employer. Now husband is already retired.
Your lordship kindly, your lordship kindly have a look.
They have never produced any rent agreement.
This is a way. He is making submissions and we are shooting. You come running and start shouting when he is making a submission. What is this, sir?
Your lordship
Take your seat. Please take your seat. We didn't ask you anything. Yes.
My lord, internal page 3 of the judgment, my lord. Just second paragraph. Mr. Kole submits that since the distance is about 47 kilometers, it cannot be held that the petitioner and her husband are working at different locations.
So where in the writ petition you pleaded that you are residing 50 kilometers apart? What have you said? Show us 2 things from the writ petition. One, that you have said you were living 50 kilometers apart. Second, that you have said that rent receipt was not being issued for this and this reason.
My lord, page 26 of my running page 26 of the can.
Yes.
My lord, paragraph 7. That although the petitioner had earlier declined to submit any such declaration, the petitioner was insisted by the senior manager P&A to submit the said declaration again during first week of March 2022, when the petitioner had visited him again on the same subject by describing that the benefit of HRA can only be granted if the petitioner submits such declaration, petitioner and her spouse living at a distance beyond 50 kilometers. Finding no other option, the petitioner submitted a declaration hoping that actual application for HRA will be granted. And my lord,
that is not a statement that you are living 50 kilometers apart.
And at my representation, I have stated also, my lord. And my lord, I am submitting that is
Running page, my lord, 46, my lord, tenancy agreement. I have submitted.
Where the rent has the
License agreement, page 46, running page. 11 months agreement. My lord has got it, my lord. And my lord, page 50, my lord, in my representation, I have stated the distance between us, my lord, 50 kilometers. Page 50, first paragraph, last but line.
What is this declaration of 8322? Where is 8322?
Well, declaration is required, my lord.
Where is that? 8322 declaration.
Dated.
Finding no other option, the petitioner submitted such declaration on 8322. Where is that?
My lord, the declaration is required, my lord. The that the husband and wife are living separately, and this is the statutory declaration that is required to be submitted if both are, my lord, residing separately.
In the opposition, they have said anything. Where is their opposition filed in the writ court?
Opposition.
Where is
well,
your
they have-
opposition? You filed an opposition
They
before
have
the
filed a
writ court.
report. File a report.
Which page?
But in CAN report has not been annexed because of
That has not been.
my lord, I beg pardon because of we
can bring it tomorrow.
My lord, I shall not be able because of the entire writ petition bunch has been missed out, and my lord, I think my learned friend will.
My lord, kindly see page 57.
You have the report, copy of the report.
Report copy থাকলে একবার দিন না।
Petitionটা তো এখনো দেখতে
আমার ওই briefটাই চলে গেছে।
আমারও তো briefটা দেখতে
Just want to see what your stand was. You
My lord,
think-
kindly come to page 53.
We are asking you to show us your report. We understand that you have found that he is 47 kilometers. We have seen from the single judge order. Therefore, we are asking. Just show us your report. Let the learned advocate for the respond number.